Okay, everyone, we're ready to get started. Please take your seats. Okay, welcome to the Rocky Mountain Professional Landman Conference. I'm Holly Krucka, Executive Director of the School of Energy Resources. It's really an honor to be able to kick off this event today. But I have to call attention to our amazing students, especially our student chapter, the Energy Resources organization. Without them, this would be an every other year event, but they would not take no for an answer. So here we are doing an annual conference, and we had great interest and really appreciate you all being here. So this is a really exciting time to be in Wyoming, to be at the School of Energy Resources and be working on energy. We have a lot of opportunities and a lot of challenges. Oil and gas investment is too low to meet demand in the future. We know that globally, which makes it a great opportunity to invest in that now. So we're grateful to the Wyoming legislature, which in the last legislative session appropriated $2.5 million to the School of Energy Resources to jumpstart our Maui program to look at unlocking the potential of Wyoming's largest unconventional oil and gas reservoir. And we're really excited about that program. We have so far a few seed projects from units all over campus contributing to helping the state. We've had some stability in coal. It's of course challenging for the coal sector with the LNG terminal shutdown and lower coal prices, but the School of Energy Resources, we're doing everything we can to support Wyoming's coal sector. We're actively working on a coal refinery demonstration in Campbell County to create non-energy products from Wyoming coal. We're working on a number of commercial scale CCUS projects, and carbon capture and storage is at a very exciting place. We are actively working with industry to try to hand off the baton from research and demonstration and deployment. So it's certainly an exciting time for us that have been working on that technology for our careers. And then we also can look at some of the things that collaboration with industry has yielded success on. So the School of Energy Resources Center for Air Quality, which is housed in that Atmospheric Sciences Department in the College of Engineering and Physical Sciences, they've been working with Wyoming natural gas producers for many years to reduce their methane intensity. So they're looking for any methane leaks in their production and their transportation. And this Center for Air Quality here at the University of Wyoming is really able to help them identify the sources of some of those leaks. And then the producers, really Pure West and Jonah in particular, invested in reducing those emissions, working with DEQ. They've worked with third parties to quantify it. And today, Wyoming natural gas has the lowest methane intensity in the western half of the United States. And Jonah and Pure West have both had structured deals to sell their differentiated gas at an incremental higher cost. So it's just such a great example if we continue down these paths, working on CCUS, working on our coal refinery, but collaborating with industry, that we really can make an impact. And I think that's really inspiring for all of us. So, and then we have our students that are graduating from the School of Energy Resources that are gonna help structure and put together these deals. And that's what we're here to focus on today, is that Landman concentration and how are we going to put together the deals around new energy technologies. So we know that the US needs more of everything, and the world needs more of everything. We need more energy, we need more critical minerals, we need more uranium in particular, especially domestically mined. We need rare earths. But we are at the same time having new challenges to producing those. So there's more paperwork, more upfront investment associated with producing all these materials. And so it's a big challenge as you look at putting together energy deals. And the permitting process and the benefit to national security, they really haven't been tied together. So it's just a really challenging but interesting time. For example, in Wyoming, our rare earth element, we have a big deposit. We have a few big deposits that have been announced. The most advanced is near Upton, and it's on U.S. Forest Service land. So it's gonna be a challenge to get the mine up and operating there, but it's something that otherwise, if we can't figure out how to mine these materials here in the US, they will continue to be mined exclusively overseas and often in countries not friendly to us that have demonstrated a willingness to use energy and materials as weapons. So, not literal weapons, although they are in literal weapons, but as trade strategies to get what they want. So we also really understand, I think, better than ever, the importance of restarting uranium mining in the US. Of course, Wyoming has the uranium reserves. We have the potential. We just need to figure out how to compete with subsidized state-owned entities overseas and how to make sure that we're mining these materials in the right way. So, on carbon capture and storage, I accidentally did this yesterday, so I won't steal Professor Koski's thunder, but there's some really exciting and crazy developments in pore space leasing associated with CO2 storage on BLM land. It is truly the Wild West as this technology is starting to get deployed, and so I hope you find that interesting later today. So one of the other things we talked about in our board meeting yesterday was that as we put together energy deals in the future, we're going to need to do things like quantification of greenhouse gases for the full life cycle of the energy project. So that kind of thing is moving forward, and it's something that land professionals are going to have to understand. And then we also have to understand, what does it mean to implement environmental justice? It's being required for our DOE projects that we worked on, even projects that that were funded before this administration. It's being added to those projects. So it certainly could be or is being added to NEPA, so it's a new area. And there's just almost an infinite number of things that land professionals are going to need to know, and we're really honored to be part of that training. So it's a super exciting time. The School of Energy Resources realizes that we need to be training more students that are very multidisciplinary. So under the direction of Cami as our academic director, we have added a 3+3 with the College of Law. And of course, getting that law degree and focusing on energy is so important to making energy deals happen. We have the nation's first CCUS certificate that will be offered in the fall. We have a land administration certificate that will be also starting, students can enroll in that starting in the fall. And we're working with Idaho National Labs to have a Fundamentals of Nuclear course that is the first time, and we're looking with them to build a curriculum around nuclear at the University of Wyoming. So with that, we're so proud of our students. We're proud of our graduates. They're incredible individuals. I credit them, especially our senior class today, for helping change the trajectory of our academic program. Despite how incredibly amazing we need more of them. We're not graduating enough students to meet industry needs yet, but it also speaks to how amazing our students are, that we have 100% placement for our students in careers since 2016. So they are doing wonderful things. We're so proud of them. And so a call to action, if you know any high schoolers, tell them about our program. We have great outcomes. The world needs more cowboys, but not just any cowboys. The world needs more Landman cowboys. So thank you so much. I hope you have a great day today.
Thank you, Holly, for that warm welcome and kickoff to the conference. Next up, we have Jake Hassman, who is a shareholder attorney at Beatty & Wozniak PC up in Sheridan, Wyoming. He maintains an active energy and natural resource-based legal practice and has practiced law since graduating from the University of Wyoming College of Law in 2007. The program has him listed as the vice chair of our industry advisory board, but as of yesterday's meeting, he is now our new chairman. We are thankful to have him and his expertise to guide our academic program. Jake has also frequently delivered the ethics presentation for WAPL, and we are delighted to have him share his ethics presentation with you all today as well. After his presentation, we'll have a networking break until 9:25, and don't forget to purchase those raffle tickets during the break or on your check-in tables.
Thank you, Cami. Before I get started, well, first off, my name is Jake Hassman. I am an attorney here in Wyoming. I office in both Sheridan and Casper, but primarily live in Sheridan, Wyoming. I am with the Office of Beatty and Wozniak, and as Cami indicated, have served on the Industry Advisory Board since the inception of the program. And I too, as Holly said, would like to thank the students for all the hard work they put in on not just this event, but many other different things here at the university. They're a very engaged group of students, and it's been just a pleasure and a joy to work with them. I'd ask at the networking session after this that everyone make an opportunity to meet one of them and kind of ask about their experience in the program, because it really is a great program, and I think they all really enjoy it a lot. Ethics in the oil and gas industry is a pretty broad topic. I have done some version of this speech numerous times for both AAPL and WAPL events. I have focused this and tailored it largely to Landman, and I'd ask that the Landman students particularly pay attention. As you get into your careers, you're going to realize ethics are constantly something you think about and constantly something you need to continue to study and just keep in mind. And we'll go over some of those key factors. To start, the Code of the West. In 2010, this was adopted via statute in Wyoming. Governor Friedenthal was behind that. But it is at its very base in Wyoming kind of our ethical code. Live each day with courage. Take pride in your work. Always finish what you start. Do what has to be done. Be tough but fair. When you make a promise, keep it. Ride for the brand. Talk less, say more. Remember that some things are not for sale, and know where to draw the line. Today I'm going to talk about various ethical rules and codes that AAPL and WAPL have implemented, along with some common law aspects surrounding conflicts of interest and confidentiality. And while the Code of the West kind of sums this up succinctly, you're going to find that all 10 of these points often get repeated in more formal codes. So just to keep that in mind, this Code of the West, us in Wyoming, we take it very seriously, and it is something we live by, and we do all ride for the brand. Just to start, ethics generally can be defined as a set of moral values which govern the actions of an individual or group of professionals, or moral principles that govern a person's behavior or conduct of an activity. So what we're really talking about here today is how you carry yourself in your profession. And the very first thing I'll say is how you carry yourself in your profession and your reputation is perhaps the most important thing you have as a practicing landman, and really any job in the energy industry. Geologists, engineers, attorneys, we all work together, and reputation is so critical. As professionals in the industry, we're professionally trained. We've completed a minimum course of study in their chosen field, or in the case of the students, are well on our way to completing that course of study. We have ethical and fiduciary responsibilities, and we all follow some sets of professional standards. Some professional groups, like doctors, attorneys, and real estate, can actually prohibit a professional from practicing, as these professions actually require licensing from a state body to practice, which can be revoked or suspended. All of the oil and gas professionals, and landmen, or at least those landmen who are members of the AAPL and WAPL, which is most, are subject to professional codes of conduct. While the land profession is largely unregulated at a state level, there's been an ongoing debate for and against additional regulation of landman within the AAPL and allied local landmans associations like WAPL for many years that mirror the national debate over whether more or less governmental regulation of the private sector is a good or bad thing. The AAPL's mission is to promote the highest standards of performance for all land professionals, to advance their statute, and to encourage sound stewardship of energy and natural resources. Regulated or not by a governmental body, AAPL and WAPL certainly place one of the strongest emphasis on ethical conduct in its bylaws and its associated code of ethics and standards of practice. But why ethics? Our industry is built upon individuals doing and saying things correctly. It's that simple. Everyone in the business relies on us being ethical, whether it's the landowners you're working with, other colleagues at other companies, and even the people you work with within your own individual company. And ultimately, our success in the industry depends on these ethical standards and how we carry ourselves as people as we work towards this goal of energy production. As I indicated, for Landman, ethics and ethical conduct are a huge focal point for both AAPL and WAPL. As you're aware, Landman are often the first representatives from the oil and gas industry that landowners or the public meet. It's often their first experience with the oil and gas industry or any other energy industry. And this really carries great accountability. Membership in AAPL represents competency, fairness, integrity, and moral conduct in business relations. I indicated that the AAPL has expounded both a code of ethics and their standards of practice. The code of ethics at its base are the basis of conduct, business principles, and ideals for its members, and were established to inspire and maintain a high level of professional conduct. Enforcing the code of ethics with specific conduct examples, business principles, and ideals are the AAPL's standards of practice. Every AAPL or WAPL member, when they have membership in those organizations, pledges to do business in accordance with these standards. So let's go through a few of them from a pretty high level. From kind of the 10,000 feet overview, at its bare minimum, the Code of Ethics and Standards of Practice, first and foremost, dictate that the landman must act with fair and honest dealing with landowners, industry associates, and the general public so as to preserve the integrity of the profession. There's an adherence to a high standard of conduct in fulfilling the fiduciary duties to the principal. So your boss, your employer, even if you're a consulting or contracting landman, to whoever your client is. Avoiding business activity which may conflict with the interest of your employer or client or result in the unauthorized disclosure or misuse of confidential information. That is a big point in all ethical codes in the industry, and we'll explore that a little more in my speech from a judicial and common law perspective as well. Performance of professional services in a competent manner, and avoiding any act or conduct which causes disrespect or lack of confidence in the member to act professionally as a land professional. And that can kind of be summed up by protecting the public interest. When landmen violate the codes, the AAPL and WAPL both take it very seriously. If there is a complaint filed or lodged with either organization, they have procedures for investigating alleged violations of the Code of Ethics, and consequences of that can include a complaint being received, a complaint forwarded to the Ethics Committee of the AAPL. Those reports are strictly confidential, but the AAPL and WAPL, if necessary, will thoroughly evaluate and scrutinize those reports. And if there is no violation, it can be dismissed. But what happens if there is a report? My understanding is the AAPL scrutinizes it through its ethics committee. They'll really hold kind of in pretty formal hearings, actually, for ethics violations. And if a possible or probable violation is found, they'll institute a formal investigation, fact-finding mission, basically. They'll hold a hearing. And if the committee finds an actual violation, the results can be a censure from the organization, a temporary suspension of membership, permanent expulsion from the association, or sometimes a negotiated voluntary agreement to resign. But really at the bottom line, what it comes down to is through noncompliance, your reputation and credibility are at stake. You know, this will become record. Other people in the profession will know that you've had an incident and have been found or penalized by AAPL or WAPL, and ultimately it just affects your reputation, which is the biggest thing we have in this industry amongst our professional. I do have at the end of these slides links to all of the various codes and standards from both AAPL and WAPL. I kind of designed this slide deck as a resource for Landman. Really, I personally think every year you are required as members to have an ethics credit. and you should really be thinking about ethics all the time. So my goal with the slides and the materials is that you guys have this to consult, because it is so important to just consider how you act and carry yourselves in our world. I am going to touch on attorneys a little bit here too, since we all work together so often. Attorneys are licensed by the state. They have model rules of professional conduct. Our ethical rules, this is them. It is a large book. It has plenty of examples. It's a set of rules that prescribe baseline standards of legal ethics and professional responsibility for lawyers in the United States. Almost every state has adopted it, including Wyoming. And Wyoming rules are legally enforceable against attorneys in Wyoming, as well as any attorney who may be practicing here on a pro hoc vici basis. So that's out-of-state attorneys who've been authorized to practice for a limited basis or matter here in the state. The attorney rules are self-regulating and policing and administrated through the Wyoming State Bar. And consequences include private reprimands, public reprimands, temporary suspension of licenses to practice law, and permanent disbarment. And if those things happen, believe me, they'll be in the news. You'll read them in the Casper Star Tribune. You'll read them in your local papers. It is a very big deal and includes lots of fact-finding and hearings when someone has to go down that path. So it's not these ethical rules. The point is, it applies to all of us. Just a brief overview of the various duties that are covered by this book. Duties to the client, duties to the court, duties to the profession. And you're going to hear a lot of these words for all the professions throughout my speech. We have the duty to maintain confidentiality, to be diligent and competent, to avoid commingling of funds, so protecting client funds and money, avoiding self-dealing, providing an effective assistance of counsel, avoiding fee splitting, rules regarding how we withdraw from representation of a client, obvious duties to the court, disclosing any instances of perjury or disclosing even adverse authority if we find it, and duties to the profession, including limitations on legal advertising, reporting misconduct, and avoiding frivolity and legal filings and just the law generally. Consequences of unethical activity for attorneys kind of mirror in some ways the AAPL, including just judicial misconduct and disbarment. Obviously, your career and professional reputation is at stake. If you get disbarred and no longer maintain that license, you can't do anything as an attorney. That is an important thing. We're licensed by the state. And in addition to the rules and substantive procedural law that governs our ethical codes, the attorney is guided by his personal conscience and the approval and judgment of his professional peers, which includes clients, it includes other lawyers, it includes judges, it includes judicial staff, it includes administrative agencies you may be working at. So it's a big deal on how we carry ourselves in front of those organizations or entities. And the same really applies to WAPL and to AAPL and to Landman. Despite the fact that your code of ethics might not be this big, the principles are very similar at its very base, and you will see that as we continue on. I'll also reference, for people who are interested, the late Professor John Berman, one of my professors for professional responsibility at the University of Wyoming College of Law, wrote this book called Professional Responsibility in Wyoming. And it is really the Bible for attorneys to consult when we have issues that come up. So it is an issue that is studied and constantly at the forefront of legal practice. And within our industry, I think it's important that professional responsibility and ethical conduct be at the forefront of oil and gas generally. We'll touch on one circumstance here. Do we have in the room any landmen who are also licensed attorneys? Tatiana, you're my example. So many landmen, as we know, are also attorneys. And as the previous slides indicate, attorneys are governed by numerous ethical rules and licensed by the state. So those are matters of state law. Some of these rules apply even when an attorney is not acting in the capacity or the role of an attorney. So let's say you are a licensed attorney, but you've kind of left legal practice behind and are just acting as a landman. If you're licensed, this still applies. Most relevant to an attorney who's working as a landman is 8.4, which states it's unprofessional conduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And a lot of authorities have interpreted Rule 8.4's duties as applying even when an attorney is not acting in the role of an attorney. In Wyoming, about 8 years ago, this was a big deal. The Wyoming State Bar changed its definition of the practice of law. The definition of practice of law in Wyoming is providing any legal service for any other person, firm, or corporation with or without compensation, providing professional legal advice or services where there is a client relationship of trust or reliance, including appearing as an advocate in a representative capacity, drafting pleadings or other documents, or performing any act in a representative capacity in connection with a prospective or pending proceeding before any tribunal. So we have a lot of landmen. I know we have attorneys in here, but is there landmen in here who have drafted legal documents? I mean, the obvious answer is yes, 100%. I mean, they do. They'll send them to attorneys to take a look at and comment on. But the bottom line is land practice is the intersection of the oil and gas industry and law. And so when this definition changed, WAPL and AAPL had its concerns. When you negotiate a lease or an SUA in the field, are you engaging in the unauthorized practice of law? If you're negotiating any land instrument that affects legal rights, a release, an extension, I mean, the examples are limitless. So this became a big issue for AAPL and WAPL. And as a result of that, AAPL and WAPL made a push and lobbied the state bar to come up with an exception to the rule of practice of law for landmen. And that, after much discussion about it, Mark, were you involved in those discussions? Yeah, there was a lot of discussion about it, and it was a very big deal, but they came up with acts historically performed by landmen relating to the lease, purchase, sale, or transfer of an oil, gas, mineral, or mining interest or other interest incident to oil, gas, mineral, or mining interest in real property, or not prohibited if the acts are performed by a landman who does not hold himself or herself out as an attorney licensed to practice law in Wyoming or another jurisdiction. The acts are in conformance with regional best industry practice. I would argue that regional best industry practice is set by the great standards set by AAPL and WAPL in many of their guidance to landmen, and that the landman is not a member of the Wyoming State Bar. So it carves out this exception, and landmen in Wyoming can continue to do the traditional land work that we've always done, and that you've always done in the state. The one thing to keep in mind, though, Tatiana, is you still hold a license, so this doesn't apply to you. So if anybody or anybody on your staffs are a Wyoming licensed attorney who's acting in a landman capacity, they need to pay attention and keep up on the attorney ethical rules as well. Quickly, I will touch on engineers and geologists, though I won't go into it too far. You know, as part of the oil and gas industry, we all work on teams where engineers, geologists, accountants, you name it, are all working together. And I just wanted everyone in this room as landmen to be aware that while engineers and geologists will always say they get everything done before you guys, there's no question there, they too are held to these standards if they have memberships in their professional organization. Engineers are regulated in Wyoming, at least for professional engineers, by the Board of Registration for Professional Engineers, which also expounds standards, encouraging the professionals to exhibit the highest standards of honesty, integrity, and competence. I think that's the 5th time we've heard that phrase. In Chapter 5, Section 7B of those rules, the board also adopted and incorporated the National Society of Professional Engineers Code of Ethics for Engineers. Just like with landmen, complaints against engineers can be filed with the board in writing in order to obtain and investigate facts relating to violations of the rules and regulations, and this also results in a quasi-judicial process with similar consequences as to landmen and attorneys. Geologists are the same. Professional geologists are governed and licensed by the Board of Professional Geologists. Again, we see those buzzwords: honesty, integrity, loyalty, fairness, impartiality, candor. These are standards you're going to see in all of the various ethical codes that people must abide by in our industry. Again, complaints against geologists can be filed with the board. This really applies to professional geologists and engineers, but I think if you talk to serious ethical geologists and engineers, they also recognize from the get-go that they have these ethical standards, whether they're licensed as professional engineers or geologists or not. So really the moral here is we need to adhere to ethical principles, and I think these are the big ones. It helps to maintain your personal integrity in our profession. It helps to maintain the public trust, which cannot be understated. It makes your public relationships easier. If you act ethically and you act as a good landman in the field, it's going to make your interactions with people in the public much, much easier. If someone questions your work and you act ethically and you make that a priority, you're going to know that you acted professionally. And it will distinguish you in a business or personal setting. Any questions just on the various codes? Doug?
Anything from the bar to update what a landman traditionally does to cover all the things that are not oil and gas related now?
Not at this time. That's probably a good idea to bring to WAPL and AAPL, since in the last 5 years, obviously that's expanded. I know we talked about that last evening with looking at other renewables that might not have been here. CCUS, hydrogen, helium, I think a lot of the functions are the same, but, that exception says things done traditionally by landman. What was that in 2012? But I personally think you're still covered so long as you're providing that general land function. But it's a good idea, and that could be something that is discussed with AAPL, WAPL, and ultimately the state bar. It's not just an issue in Wyoming. I've focused this on Wyoming, but every state has a statute on what's unauthorized practice of law. Not all of them have as concise an exception as Wyoming does. So each state does it a little differently. I know Colorado's people have argued is a little chaotic at times on how you determine that. But I think generally, especially your oil and gas producing states, recognize a carve out. But you're right. As the landman profession continues to evolve, do changes like that need to be discussed so they're protected and don't get caught in a situation where they'd be accused of unauthorized practice of law. Any other questions on just the various codes? Mark?
Just a follow-up to that. AAPL, who has drafted a lot of these exclusions, is looking at that same thing that Doug just brought about.
Great.
And their argument that they look at is under the codes that have been establishing that the term energy agreements, the development and operation of standard or practical or normal energy agreements, I think you could extrapolate that, doing core space or ammonia or something, uranium or something else that's not traditionally oil and gas would probably have a degree of coverage, but it might be something for us to look into.
Yeah, and I agree with that 100%. Any other questions? And otherwise, I'm going to kind of move more into some specifics from the codes, the big ones being avoiding conflicts of interest, protecting the public trust, and confidentiality issues. Those are really 3 things that are so central to everyone who practices in oil and gas here in the state of Wyoming and regionally in the whole country. So we'll go into some more specifics instead of just the generals on where you covered. To start, there we go. To start, generally Code of Ethics forbid conflicts of interest. They spell out the extent to which such conflicts should be avoided and what the parties should do where such conflicts are permitted by a Code of Ethics, whether that's disclosure of conflicts, recusal from representation, and there's other options too. For attorneys, this is covered by Model Rules 1.7 through 1.9. These rules prohibit the representation of one client if it will be directly adverse to another client, or if there is a significant risk that the representation of that client will be materially limited by the lawyer's responsibility to another client, a former client, or a third person, or by the personal interest of the lawyer. Rule 1.8 identifies specific rules regarding conflicts, including no business transactions with clients, no gifts from clients, etc. And 1.9 covers duties to former clients, including conflicts of interest, which we'll cover in subsequent slides. Rule 1.10, conflicts of interest can impute to other attorneys in the firm as well. So for example, I do a lot of work at the Wyoming Oil and Gas Conservation Commission, and conflict of interest evaluation is a constant. I see Will Reese in the crowd, he knows as well. We constantly can run into conflicts where one of our clients suddenly has an issue with another of our clients, and we've got to evaluate that and generally withdraw if that's the case. That does impute to other attorneys in your firm, so if that happens with my clients, Devin, who's also at Beatty and Wozniak, that same issue is going to affect him. And that same idea applies to Landman. Landman are covered by their Code of Ethics Standards of Practice, and it's even included in their preamble. It's such important. The land professional shall exercise the utmost good faith and loyalty to their employer or client, and shall not act adversely or engage in any enterprise in conflict with the interest of your employer or client. The standards of practice also indicate that avoiding business activity which may conflict with the interest of his employer or client or result in the unauthorized disclosure or misuse of confidential information. And in the preamble, I think states it best, in accepting employment, whether it's actual employment or you have a client, the land professional pledges himself to protect and promote the interests of that employer or client, and this obligation is of absolute fidelity to the employer's or client's interest. So they're saying the same thing as attorneys. If you have a client or you have your employer, you work for them. You work for them. You don't work for other people. Obviously, you may have other clients if you're a consulting landman, but you have to evaluate those clients. You're not going to want to take a leasing project where, in a township area where both your clients are leasing the same stuff at the same time. That at its very base is problematic. That's just an easy example, but this applies across the board to so many situations. So what is that solution? The first would be avoid them entirely, which, as we know, can be really hard to do if you have a large client base. The big rule is, if you do discover a conflict of interest, is disclosure. Be forthright. Disclose that to both clients with the conflict. They may be okay with representation. If that's the case, you can obtain a waiver of that conflict. It's always recommended that waiver be obtained in writing, but the key to obtaining a waiver, first and foremost, is full disclosure of what you've been asked to do and the potential conflict that's arisen. Another one is recusal, and this often happens, and I again, Will, sorry to use you an example, but it's commonplace. We have conflicts, and there's times when we just can't represent either party, and if that's the case, we have to refer them to someone else because that conflict is so strong between the parties that there's no way you can effectively represent it without harming another client. The bottom line is looking to the provisions with each respective code standard to avoid conflict of interest situations is key. The Wyoming State Bar for attorneys has an ethics hotline, which is a useful tool where we can call to discuss issues like this, along with other possible ethical issues. And I've found that it's just a useful tool to have bar counsel to buzz that on. I think the AAPL also has lots of information, including various examples on how to handle yourself in conflict of interest situations. Before I move on, any questions on conflicts of interest?
I'm wondering, will the state bar waive a potential conflict of interest to allow a client to obtain representation? Like the Oil and Gas Commission only has a few attorneys working there,
Mm-hmm.
and some of us feel like other companies have a practice of
That's a tough one. As I indicated, our ethical rules as attorneys are pretty much self-governing. So we're really not asking the bar for a waiver. We have to deal with the clients on that waiver. So I've been in that situation too, and it's frustrating. I agree. But really, waiver is not in the control of the attorney. We have to make full disclosure to those parties. And if they are willing to grant that waiver, it'll work. If not, they're really, in my eyes, and if there's an attorney here who has a different opinion, in my eyes, that prevents us from ethically proceeding and could leave us up to exposure with the state bar. Any other questions on conflicts of interest? I'll move on to protecting the public interest. AAPL's Code of Ethics and Standards of Practice provide that it is the duty of land professionals to promote and in a fair and honest manner represent the industry to the public at large with the view of establishing and maintaining goodwill between the industry and public and among industry parties. It also indicates that the land professional is dealing specifically with landowners, industry parties, and others outside the industry will be conducted in a manner consistent with fairness and honesty, such as to maintain the respect of the public. It continues, as this is a big thing, is how we represent ourselves to the public in the industry. It is the duty of the land professional to protect the members of the public with whom he deals against fraud, misrepresentation, and unethical practices. And the landman shall at all times present an accurate representation in his advertising and disclosures to the public. So no tricky statements and negotiations. The key is to be honest and forthright with who you're dealing with, but obviously that can be difficult in certain situations. Attorneys also have a comprehensive duty to protect the public interest by following the similar rules in their model rules of professional conduct. But why is this important? By protecting the public against fraud and misrepresentation and eliminating unethical practices generally, an industry professional eliminates practices damages to the public or bringing discredit to our industry. Absent a strong relationship with landowners and the public at large, growth of our industry can be significantly impeded. And in my opinion, one of the best ways to protect the public interest is the golden rule. Treat others how you would like to be treated. Make full disclosure, be honest in your statements to the public or landowners, but within reason. You want to keep them informed, but you also owe duties to your client and your employer. So you have to really balance those duties among each other. We'll look at some solutions in a minute, but just attorney ethics rules, contract law, and tort law, so the law, recognizes that a party generally does not have an affirmative duty to disclose information to the other side. But you can commit fraud or misrepresentation even without making a false statement or something that isn't true by partially disclosing information that's literally true but isn't the full story, that would be misleading when other information is also not disclosed, and by failing to correct prior statements that may have been inaccurate. So what we're really saying there is you do have this duty to be honest and give truthful disclosures to the people you're working with in this industry. But you owe a duty to your client too. So you need to know the certain role you are providing and what information you are able to share. So some solutions and guidelines I look at is for the landman. First off, you want to clarify your role as a representative of, let's say, the lessee or the operator, and not the lessor landowner. You're there for your client. You're there for your employer. If you're negotiating an oil and gas lease, a surface use agreement, certainly it can ultimately provide a benefit to who you're dealing with, but you do not want to make them feel like you're doing this for the benefit of them. You're doing this for the benefit of your employer. So clarifying that role from the first step and saying, I represent Jake Hosman Oil, and I am here to obtain an oil and gas lease for Jake Hosman Oil is very important. Another big one is a landman should not encourage a landowner to sign a lease or any other legal document without taking the time to read it. You need to allow people that time, and pressuring them to sign it straight up is unethical. Landman should not discourage a landowner from consulting with an attorney. We know we have a lot of savvy landowners in the state of Wyoming who understand oil and gas law and get it. And it may be discouraging if they get attorney, including certain attorneys that you may work with that are frustrating, but you should never discourage them from using that avenue because that is their right. This one's a little longer, but landmen should avoid discussing or answering questions about oil and gas law. That gets into unauthorized practice of law. That is an attorney's job. The legal effect of the lease, whether the lease is a good deal, what the lessee's future plans are, and I'll preface that with unless your employer or client has allowed you to share what those future plans may be. How much the lessee has paid others, that's a tough one. Neighbors always want to know what other neighbors get done and generally are going to ask that question. But again, without a scope from your employer on how you go about that, that should not be shared. And whether the lessee would pay more than the lessee is currently offering. If a landman receives questions and doesn't know the answer, say, I don't know. That is not a harmful statement. Say, I don't know, and I can look into that and talk to my client or employer, and if I can find an answer, I can get back to you. But you can't claim ignorance if you know the answer. That in itself can be construed as a misrepresentation. The safest answer, and this is what I recommend with everyone, is to know the bounds of your employment. You should have instructions from a client or your employer on what you are tasked to do, how you are to do it, and what information can be shared as you're doing that. So a safe answer, if you don't know exactly what those bounds are, is I'm not authorized to discuss, for example, the lessee's future plans, the legal effects of the lease, whether the lease is a good deal, things like that. But it's fine to say I'm not authorized, but let me chat with my employer, let me chat with my client, and perhaps I can get back with more information to supplement that. Sometimes in a negotiation when you're sitting at the dining room table on a ranch, that isn't what they want to hear. But by doing that, you're A, protecting yourself from perhaps giving information that's not true or inaccurate, and two, you're protecting your employer and your client because you're acting within your role to the extent you've been authorized to do that role. Any questions on some of those examples or how we protect the public interest? Okay, we'll move on to one of the big ones that we all deal with all the time, and that is confidentiality. We work in an industry where information is highly confidential, whether it's leasing information, certainly geology information, proprietary methods of drilling and completing wells, and just, as for attorneys, just handling any client information. So a landman should not betray his employer's or client's trust by directly or indirectly using confidential information for personal gain or any purpose other than for the benefit of his employer or client without their prior consent. So bottom line is, most of the things you are doing for your clients likely are confidential and very important to that client. If you're not allowed to share that information, don't do it without consent. Again, there's certain instances where you'll work in negotiations and that becomes relevant information, but that should be shared in the scope of your roles. Don't just assume that all information can be shared. The other provision, big provision, is the landman shall exercise the utmost good faith and loyalty to his employer or client and shall not act adversely or engage in any enterprise in conflict with the interest of his employer or client. That's a big one, and that's one where we oftentimes can't actually see litigation involved, and I'll get into that here in a minute. In addition to these ethical rules, parties owe common law fiduciary duties to their clients and employees. So common law meaning basic legal principles of fiduciary duties to your client's employees. And there's a duty not to disclose confidential information gained in the employer-client relationship. Breach of fiduciary duty like this is actionable in a judicial setting. So even outside of any of the codes I've talked about today, breaching a fiduciary duty can result in court, and long drawn-out court. This duty survives the termination of an employment or client relationship. So if you're a former agent, so an employee, or it was a former client, a former agent, you may not use or disclose confidential information gained in an agency relationship after that relationship is terminated. So if you were a broker and you were taking leases and have all this lease information outside of Laramie County and switch jobs to a new broker, you still have a duty to that old broker. That was their confidential information. You do not use that information. That is a big problem. Certainly, employment contracts can modify that duty. Employment contracts are often going to outline the scope and the lane of your employment and can define this specifically, so that's a big thing too. If you have an employment contract with your employer or your clients, know what that says and know the scope of your employment and what you can and cannot do, share, or use. Because consequences of breach of this can include disciplinary action from your licensing body. So this idea of common law fiduciary duty really does mirror what these codes of ethics say. So if you do something like this, not only will you maybe end up in court, but you could end up in front of your AAPL board, the state bar, any other licensing board. And there's also judicial liability, and in some instances, punitive damages, which can get very high. Two examples of this, the Tenneco Joyner case. In this one, a landman acquired confidential information about profitable prospects during the course of his employment with an oil company. After leaving that company, the landman then went out and directly acquired 30 leases in that same prospect based on that information he took from his old employer. The court found the landman in breach of the duty owed to his former employer to not use confidential information. He had taken those leases, and they actually imposed, as they did in the next one I'll discuss, a constructive trust, meaning those leases still were in his name, but any benefit deriving from those leases went to his former employer. So he got nothing because you cannot use that information. The Tlapek v. Chevron case is similar. The geologist used a company's confidential information to develop a theory about the location of a very lucrative prospect. He was the one who developed it, but it was within the scope of his employment for Chevron. They refused to begin further exploration until further data confirmed his theory. He was upset that they didn't act faster, so he went. He went out there, he personally acquired leases in the prospect lands in direct competition to the employer he just left, and the court found that the geologist breached his fiduciary duties and imposed a constructive trust in favor of the former employer, just like in the previous case, over all the leases he acquired. So while he may have developed that information, he developed it for the benefit of his employer, for Chevron. He then used it to the detriment of his former employer, and while those leases were deemed valid, he receives no benefit whatsoever from those leases. So the confidentiality one is one that you actually see hit the courts fairly often. I know there's been several that have been ongoing in Wyoming. Lots of them settle. Sometimes you don't get opinions, but the confidential information, that information is so valuable to our clients or employers that if you decide to move down that road and try to use that information, it could be extremely detrimental to you, both your reputation and ultimately financially. Some solutions and guidelines to the conflict of confidentiality is to recognize and respect the ethical obligations arising under both your codes of ethics that you have prescribed to and those general fiduciary duties I just discussed. Avoid taking or attempt to avoid taking a new position with a company working in an area that is in direct competition with your current or former employer. That's always going to present the risk that you are even if inadvertently, using confidential information you knew in that previous role. But if you are taking a new position with that company, adverse or partially adverse to your current or former employer, ensure that that employment to protect yourself as well as your former company, as well that you still owe this duty of confidentiality to, ensure that that new employment involves projects that aren't directly adverse to a current or former employer. And most importantly, if you learn information in the course of your former employment is confidential, a trade secret, or could be used to the detriment of that former employer, don't use it, as serious legal consequences will follow. Any questions on confidentiality? I've just got a couple more slides here, and one big things to remember that, unhappy landowners will almost always question your integrity. They just will. That's how it works. I would say the same thing about regulators. Really, anyone you work with in the industry, one of the first triggers to when someone becomes unhappy is to question the other side. You will be held to a much higher standard in the oil and gas industry because of your knowledge in our industry. And following these codes and standards will provide you with the credibility within the industry, as well as a possible defense when or if you are ever accused of misrepresentation or unethical conduct. To conclude, at all times, be familiar with your applicable codes of ethics or standards of practice. Use common sense. If you're engaged in something that feels fishy, it might be fishy. Know the boundaries of your employment situation. Know your role. Know your instructions. If you have an employment contract, know what your bounds are and how you are acting for your employer or client. Every time you have a new opportunity, conduct a conflict check to ensure you're not suddenly have a conflict between an existing client or employer. Do not use confidential information learned during former or current employment, as serious legal consequences may follow. In addition to the duties owed to your employer and client, keep in mind you have those duties to the public and protect that public interest. Be truthful, honest, and accurate in your representations, as representation is critical to all of our careers in the oil and gas industry. Last slide I just have, and Cammie, I am happy if you share these slides with anybody and everybody, especially the students. This last slide just contains links to the AAPL's policies and bylaws I've looked at, their code of ethics and standards of practice, as well as WAPL's. You will find WAPL's mirrors AAPL almost exactly. I'd encourage you to talk to your WAPL and AAPL representatives as well about other ethics-related resources that they publish or have. I know AAPL has a lot of ethical resources available on their website. But that's all I have for today, unless anybody has any questions. Yes, sir.
Have you seen in your practice use or attempt to use AAPL or maybe APL as a standard conduct for non-affiliated landmen if there's an issue of a potential violation of fiduciary or whatever?
That's a good question. I've seen it as an analogous, used as, you're a landman, and while you might not be an AAPL or WAPL member, at large, the profession, many are, and seen it used as a set of structures on how you should act. But again, some of this stuff, confidentiality, conflicts of interest, and this idea of being a fiduciary for your employees, even in the absence of WAPL and AAPL membership, that's common law, and we all, regardless of whatever position you have, doctor, doesn't matter, we all have to deal with those duties, those fiduciary duties, so you still owe those duties to your client, even if you aren't an AAPL or WAPL member. Any other questions? Well, sorry.
Can you expand on your earlier slide of attorney self-dealing?
Self-dealing, that's a good one. A lot of that can be financial transactions with your clients. You know, you're helping them with something, and it is going to benefit you directly financially. That's part of it. Afterwards, I can share some of the stuff in these materials here that I haven't prepared, but yeah, that's a lot of it. Any other questions? Well, I appreciate Cammie being invited, and for those of you who aren't from Wyoming, welcome to Wyoming. I hope you've enjoyed your time. And again, thanks to all the students, and I again encourage during our break here that you guys reach out to some of the students and hear about their experiences at the School of Energy Resources. Thank you.
So welcome back, everyone. Let me introduce to you Mark Strawn, who is the recently retired president of the Wolf Haven Corporation and High Story Ventures, Inc., oil and gas acquisition and divestiture companies specializing in mineral and production properties in the Rocky Mountain region. Until yesterday's board meeting, Mark had served as the chair of our industry advisory board. He now has the status as the first chairman emeritus of that board and will continue to advise on our academic program into the future. Mark has 41 plus years of field landman and management experience, and we are lucky to have his expertise guiding our academic program. Mark served three two-year terms as the director of the Wyoming Association of Professional Landmen, and also served as the AAPL president in 2015 to 2016. If you have any doubts on purchasing the Student Chapter of Energy Resources swag items available for sale today, he is the proud owner of a few hoodies and t-shirts and a raving endorsement to make sure you get yours while you're in town today. You can use the QR code on your table or purchase them at the table outside where the students have their booth. These can be shipped directly to your door, so you don't have to worry about taking them home with you today. So up next, Mark is moderating our extractive energy panel today, and I welcome him and his panel to the stage.
Good morning. I think that's the first time I've ever been introduced as a marketing ploy for the student program, but that's great. I'm glad to do it. Before we get started here today, and we're going to get into some real interesting conversations, I wanted to add one thing on with what Jake had brought up on the ethics from the last particular session that we had. The one thing that you need to know, especially as students, is that being AAPL members and members of WAPL, which is an associate of AAPL, that is a national organization. So where Jake is talking to you about suspension from state organizations like the state of Wyoming, if you get suspended or expelled from AAPL, it's national. So it's the entire country. And we just had one that was expelled here in the last issue of the Landman magazine. So take your work and your ethical standards to point, because it will follow you all around the country. Today I'd like to introduce our table. What we're going to look at for the next hour is a panel on extractive industry. But what I also want us to look at are opportunities. These are things the students have brought forward, and everything is being talked now about Bitcoin and artificial intelligence and carbon capture and everything else. But there are many different industries of which landmen are in. And although these new ones are new and important, it is also very important for us to keep a well-rounded aspect of what a land professional truly is and does, because you'll be called on those things all over the place. We talked to a gentleman last evening who's in this particular session that's in hard rock mining. And it's another aspect that a landman and a land professional does, and you need to have all those tools in your toolbox. So at the table today, I brought in a bunch of people that are specialists in Wyoming in these particular fields. So Fred Adin is sitting next to us, is with Peabody Coal in one of the largest coal mines in the state of Wyoming, and a very strong understanding of coal and coal extraction. Next to him is Mark Dolger, former member of the Wyoming Oil and Gas Conservation Commission, longtime friend. He and I have served on many state boards and agencies, but he is one of the premier geologists with Barlow and Hahn and an owner of Barlow and Hahn. But his specialty besides oil and gas is uranium. And so he will be able to give us some insight, hopefully, on uranium and how that gives us some additional opportunities. Jason Hoover runs one of the large premier oil and gas brokerage, independent brokerage firms that Jake was referring to in the last session here in Wyoming. They're based out of Cheyenne. Jason is important to this discussion because his practice, although a lot of independent landmen do a lot of different things, and they're out doing carbon capture and they're doing ammonia and hydrogen and all the different types of stuff, Jason's practice is primarily still nuts and bolts oil and gas. And it doesn't matter where we go with everything else, there's nothing that's going to replace fossil fuels. So we all believe we need all different types of energy and all different types of things that we're looking at for the future, but we have to remember there's nothing out there that replaces completely the baseline that it is, and he serves a very important function in this state and as an independent employer for landmen in the Rockies. At the end is Marianne Green. Marianne wears two hats. Originally, when we brought her on to this particular panel, she was a senior land advisor for Oxy. And so you had the corporate side of the oil and gas industry. And if you've been watching some of the recent correspondence and ads and things that have been on the news recently, their company is very strongly trying to bridge across the oil and gas into more renewable energy sources. She now works on the renewable energy side for Western Energy? Western Land Services. And so she's bringing the crossover between that. What we need to look at today is a transition. This is a very interesting time for new landmen, but it's a very difficult time for landmen because it's actually a transition period. It isn't the same way that it was back in the 80s or elsewhere when we were doing all just oil, gas, coal, uranium. Now we're trying to get into the other fields, but we have to have a foot in both camps until we can make that happen. That's what we're going to talk about today. So where I want us to go is I'm going to start with some questions, but I want us to look at opportunities, and I want us to see and give these students a better understanding of where things are at this particular point in time. I want to start first of all with Mark Dolger. Mark, we're coming back into an industry now that is uranium driven. We've seen so much in the paper about Russian uranium and things, but Wyoming has a major resource in uranium here. How do you see that advancing? What opportunities and ideas do you see as a possibility for landmen in the future that may not have been there in the last 5 to 10 years?
Yeah, thank you, Mark, and thank you to Holly, and a special thanks to all the students in organizing this conference. It's been delightful. To talk about the future, let's first look at the past, because back in the early 80s, that's the height of the uranium industry in Wyoming and really the US. And in the early 80s, 4,500 people were employed in the state of Wyoming in uranium and uranium mining. That's back when we had open pit mines. Those are closed now, and everything is done in situ or in place. And recovery of uranium is now basically a plumbing problem. At the time in the early 80s, Wyoming produced enough uranium to provide the feedstock to all 100 reactors at the time, 30% of the feedstock. Now we're down to maybe 1%. That is in spite of having world-class resources. Basically, Russia has knocked the US uranium industry out by providing 50% of the uranium, now coming from Russia, state-subsidized, state-owned. And so where our threshold for economic production is much higher, the nuclear generators prefer that Russian uranium because it's cheap. So we're disadvantaged, but that's turning around. When I started our project, Stakeholder Energy, some 12 years ago, the price was $80 a pound. And for a very short time, I looked like the smartest guy in the room. That didn't last, and uranium tanked and went down below $20 a pound. This week it's at $53 a pound. So it's improving. Are we there yet? Stability needs to be established before companies will restart projects. But I think the future is bright for young people. I'd say the average age of my peer group, mostly they started in the 1970s, so it's a very aging workforce. Most of the people I deal with are into their 70s and some in their 80s. So you guys are the replacement, and I encourage you to pursue that, be knowledgeable of it. And I'm going to add one more thing, Mark. On everybody's table is an outline, and there are extras out front. And when I started Stakeholder Energy, I found there were no standardized uranium agreements. There still are none, but I put together some guidelines. If you're getting into a uranium project, these are the agreements that you'll need to prepare. And my contact information is there if I can be helpful to you in any way in the future in preparing agreements.
Thanks, Mark. Marianne, one of the questions that came to us said basically that in the 80s, landmen in the state of Wyoming traditionally did oil, gas, coal, uranium type of work. In the 2000s, we switched into adding renewables into that portfolio. Since you're kind of in a crossover right now between the two, what do you see the future of the industry being? How do we handle that, or how do we prepare for that as new landmen coming out of school and moving forward with that?
Thanks, Mark. And thank you for allowing me the opportunity to be here. I think that the renewable industry for Wyoming and for the U.S. is only going to become more and more prevalent, and there will be work opportunities for everyone to capture if they so choose. As Mark mentioned, oil and gas is not going anywhere, so you need to harmonize both the conventional side and the unconventional side. And when I was with Oxy, I remember doing surface use agreements with solar companies, and now that I'm on the other side, it's interesting, to see kind of both sides of the spectrum. But I feel that my degree with the PLM program has just laid a great foundation to be able to make those transitions, and the opportunities for these students to diversify themselves in either oil and gas, uranium, solar, wind, whatever it may be, is there, and you guys can capitalize on that. So, and if I can be of any resource, please allow me to do so. Thank you.
Jason, you and I have had the privilege, I've had the honor to work with Jason for 30 plus years. What have you seen? When we started, it was all oil and gas and everything was driven along that line. What demands are you seeing being put upon you as a lead broker in that situation that is causing you to change? Are you getting a lot of demand for renewable side? Are there different skill sets that we used to take for granted that are now necessary? What are things, what changes to make your profession easier or harder at this particular point in your life?
Mark, I think, as I listen to even the panelists and what you're saying to folks here and sit and consider, that is the main takeaway for students, I think. And all of us older folks can testify. The most challenging part of being in the land business in the energy field is being able to be flexible and to change, because as we see, and you're referring to, the energy sources are new and different and emerging. As we look back to the past, all of that is driving, what we have today and where we're headed in the future. The skill sets, as you referred to, you've got a whole variety, and that's what makes being a land professional so wonderful and such a great career path, because it challenges you in many ways, and so you should be careful not to allow yourself or not to pigeonhole yourself into one aspect, whether it's communication with people, negotiations, things of this thing, or one particular energy field, whether it's solar or oil and gas, uranium, carbon sequestration, pore space chasing, all of the various things that we need to do. Just keep in mind that as the older folks are continually challenged to take their skill sets and match it up with the emerging plays and emerging technologies and emerging processes, so do you have an equal opportunity to take what you're learning about current processes and these new and exciting energies and adapt backwards to where we've all come from, which is a deep understanding of the technical aspects, not only of the legal aspects of title, but also applying those and how they relate to operations, whether it's oil and gas or coal or nuclear or regardless.
Thank you. Fred, the Biden administration has passed many new clean energy policies. A lot of it was codified under the Inflation Reduction Act and parts of the Paris Agreement that we've been working on. How do you see that affecting your role in development of Wyoming coal? Have these things been designed to help you? Do you see it as though they're trying to totally run you out of business? Are there ways to work within the system and move that forward so it's a win-win situation for all parties and all stakeholders at the table?
Thank you, Mark. Thanks, Holly and the students, for putting this together and giving me the opportunity to make a fool of myself up here. Mark, to answer your question, I don't think it's hidden that Biden's administration's agenda is to pretty much eliminate coal with one, but fossil fuels as a whole. With the current existing technology that is existing, with the thermal generation of coal specifically, with the coal market will continue to decline. However, there's a lot of work being done. University of Wyoming's leading some of that work that will allow those thermal power plants to continue to operate because they're getting cleaner. Right outside of my office, Dry Fork Station, the last power plant that was built in the United States, is the cleanest power plant going, bar none. When we look at it on a global scale, since that seems to be where the administration is leading us, China's building a power plant, and maybe off on my numbers a little bit, I want to say one every 45 days. A coal-fired generation station, not a whole plant, but one station's coming online about every 45 days. They're nowhere near as clean as Dry Fork. So from a regulatory environment, coal is, to say struggling or hindered would be a little bit of an understatement. I can say that the company that I work for, Peabody Energy, we're doing everything we can to ensure that we operate cleanly. From little things, we're converting all of our light bulbs in our facilities to LED. We're looking at going to hybrid pickups for the pit supervisors going in and out of the mine, or even full-blown electric pickups to go in and out of the mine, so that we can move the needle a little bit for the coal to be considered cleaner.
You said regulatorily. Let's look at it commodity-wise. If China's building new power plants every 45 days, ultimately, does the United States coal industry become a net exporter of product to foreign countries? Or are we moving forward, do you see us moving forward with new initiatives like the clean coal initiatives and clean diesel and some of those other commodities that the university has been working on?
So from an export to China perspective, Peabody, we occasionally will be able to ship a train. It has to come out of Colorado, and it goes, I believe, down to NOLA, New Orleans, Louisiana, shipped on a train, or a boat, then through the Panama Canal to get to China. That's an inefficient method of getting coal to China when Peabody's other operations are sitting on Australia and they just have to go straight north. I would like to see the western seaboard, Oregon, California, and Wyoming, open up. Warrior Coal and the state of Utah, I don't know what the outcome of the lawsuit was, but they sued the city of Oakland because the city of Oakland shut down a plant that they were putting together to be able to export coal out of Oakland, California. So from a getting it to China perspective, it's a struggle. However, on the met coal side, when you look at the non-thermal coal, we're exporting all the coal we can produce out of our Shoal Creek operation in Alabama. Majority of that is going to Europe, though. So from a where do we go from here? Honestly, Mark, I'd like to have a better answer for you, but I see a lot of hurdles, and I see some really good people trying to figure out how to get us over those hurdles. I just don't know that that's going to happen in the near term.
Okay. Switch subjects a second. We've all seen in the news over the last, especially the last 6 weeks to 3 months, the whole rise in the business community and stocks and everything else around artificial intelligence. And I watched a very interesting segment the other night in which artificial intelligence is being now used by the pipeline industry, because they can use artificial intelligence to automatically survey the pipes for integrity. It cuts down on leakage, cuts down on breakage, and doing all these other things. In each of your respective industries, if you have any comment to that, where do you see artificial intelligence assisting or moving that particular profession forward? Marianne, you want to start?
This is such a new emerging concept that I don't even think we have a grasp as to what the implications might be, positive and or negative. I'm trying not to be like so old school. I think of like when the calculator was invented and people were like, oh my God, you're not gonna know how to do long division, and I'm trying to embrace it. But I know that we also need to do so with a little degree of hesitation. But I don't know how it's going to fit in the renewable industry currently. Maybe it will help be able to evaluate great areas where solar or wind has not been developed, and it can make those prospecting plays easier to acquire. I'm just not there yet on how it can help currently.
I would wonder in the renewable energy sector whether just the efficiency of programs, how turbines turn, and
Sure.
and other equipment, engines and generators on hydroelectric or nuclear power facilities move forward. I would think that science would have some component piece to making those calculations faster, quicker, and thus being more efficient.
Yeah.
Do any of the rest of you see where it is starting to creep into your respective professions or industries, where you're seeing it or where you would hope that it might be going?
Yeah, Mark, I can speak to the coal industry a little bit, and whether it's AI or just advanced automation, I'm not 100% certain. But the current methodology, we mine the coal, we sample the coal, we get the results, we blend it, we put it on a train. They're in the process now of that sampling and that testing of the quality of the coal happens at the shovel. So using advanced sensors to do a spectral analysis of the coal that's being mined as it's being mined, it goes in the truck, it goes to the hopper, it goes on the train. There's no longer the laboratory component that's in there. Whether that fits in with AI or not, I don't know, but it's something that we've just started doing.
it's a level of efficiencies. So it's aiding in the efficiencies of that particular side. I was wondering from a geological standpoint, Mark, whether, you will ever, in the ultimate thing, see AI assist in analysis of geological formations or possibly reservoir management or anything along those particular lines.
Jake Hosman earlier said it's okay to say I don't know. So on the geology side, I really don't know. I wonder if there isn't an application for transmission grid management and flexibility. There's great concern that by adding renewables, there are shortcomings in the grid, and overcoming those shortcomings and managing the grid so all the pieces can fit might be an application.
Okay. Jason, do you have anything you want to add?
Very little. But it does strike me that, as you were saying, whether it's automation or whether it's truly, artificial intelligence, which I'm not well versed in, it's easy to see how something like that could be very useful and successful in pulling together information and records, public records, and compiling all of that for a human to read and a human to understand and to apply. I hear, as many of you do, the ongoing effort of hiring folks and many that are just volunteering out of sheer excitement to teach AI how to write better, how to think by showing them how they think. So it'll be an interesting process to see what human cooperation will be to the level to determine, title issues and how they relate to operational facts and rules and regulations.
I think, I think it's just still so new yet, but I think that there's all these efficiencies that institutions like the university can be looking at and that students should be looking forward to as how do you, for using lack of a better phrase, build a better mousetrap. I mean, if you can increase your efficiencies and thus make it more cost effective and or provide a higher, greater result, it seems to me to be there, but I'm not sure that we're there yet, that we figured all that out at this particular point. Let's go into another area. Mark, the proposed TerraPower projects that have been brought into the country are really drawing a new line towards nuclear power development in the United States. This university and the School of SER is really focusing a lot of attention now on nuclear energy and its role in that development. How do you see programs like Terra? Is that helping where we're at? Is that drawing more attention to it? Do you see more movement going forward along those particular lines?
Well, Mark, that's a big question, and a lot of people are analyzing potential answers to that question. TerraPower is 3 years behind schedule. That's because the specialized fuel to run that plant is only available from Russia. So now, instead of opening in 2017, it's scheduled to open in I'm off a decade. Scheduled to open in 2030. And I know companies are actively looking at developing what's called HALEU, high enriched uranium, or high assay low enriched uranium, which can be produced domestically. So it's a big question, Mark. There are many people watching TerraPower, and they are using a molten salt reactor, which is very safe and is proven. You also hear about small modular reactors. That's being looked at by other companies, one being NuScale. in all SMR developers, there are about 10 different developers. So it's coming. But there are many, in addition to the reactor, you have to look at the fuel, which I mentioned. Where does the fuel come from? And you have to look at waste disposal. And I don't like using the word waste. I'll say spent fuel, because spent fuel can be reused. And Wyoming might have a role in all of those three components. Long term, you bet. I mean, it's going to take a long time. And people are watching TerraPower. It's difficult when you're the first in the game, which TerraPower is, after a long dormancy. And cost and time, construction time, still pretty much unknown. They haven't even broken ground yet. So if you're sitting here in Wyoming watching this, you might wonder, is this for real? I think it is. That's my opinion. We have the resource, we have the interest, we have the sites with retiring coal plants. The physical facilities are there, the water is there, it's proven, and it can be converted and adapted to nuclear generation. Does that answer your question, Mark?
It gives us something further to think about on it. They said yesterday in the meetings that we were in that part of the problem with all of these commodities, and it's something that landmen need to be looking at across the board, is that a lot of them are still in their infancy. And the problem in Wyoming always has been, we are product rich, we are manpower short, and we don't have a stable supply chain to get the commodity out. So the problem like you have is we've got world-class coal, okay? So what do we do with that coal? If they're not going to allow us to ship it, then are we going to try and manufacture something here in the state of Wyoming to capitalize on that particular commodity? And so when you're looking at that, you've got to look at all these different component pieces. And I think that that's very much a problem with not only the nuclear, but a lot of the renewable energy sides of things. Let's look at the oddity of it. Again, looking at opportunities, I want to look at this because this came after I basically retired. But we're all familiar with Bitcoin and Bitcoin mining and its role, and actually Wyoming is trying to take lead on its own coins and doing things along that line. Do we still see that as being a role for landmen in the future? And I'll put a qualifier on that because a lot of it is used on spent fuel or reserve gas that's coming off of wells, but that's a finite substance. I mean, we're not drilling as many wells as we are. There are not that many wells that qualify. So is Bitcoin mining something that is really a role for landmen, or is it kind of that flash in the pan and it's this year's new thing that we're looking at and it'll go away at some point in time in the future? Anybody want to jump in on that one?
I would just say that, like you mentioned earlier, it can be another tool in your toolbox that you can, if you're an independent landman or someone who's looking for new opportunities, you can have that experience and capitalize on it. But I don't know if it's something that, and I might be a fool for saying this a decade from now, like I don't know if it's something that's going to be a driver, but there might be a need for it right now, and you can help out however you can, and maybe make some money while doing it. But I don't know that it's going to be something a decade from now that has changed the game or anything like that.
Jason, explain to them for just a minute as to why situations like Bitcoin mining come up, the skill sets that are, from a traditional oil and gas or mining industry profession, how that is linked over into something like Bitcoin mining or something on the renewable energy side.
Well, the times that I've come across it, Mark, is from clients who operate wells that are otherwise flaring gas. Once you've, by and large, taken the time to build out gathering systems and dedicate your gas and put it under contract, things of this nature, it becomes a little bit more complicated. So there may be some opportunities out there in wildcat areas that, like I said, haven't been gathered yet, and that they can be leveraged. But one would certainly think that, given environmental requirements and the economic benefits of actually selling your gas downstream, that it would be spotty. But as you say, I may look like a fool in 10 years, and that's all that there is. But given U.S. dollar and stable coin and where everything is headed, I can't imagine that regulation won't quickly overtake the cowboys.
If I was just standing here as I was watching Jason answer that, I was looking down this table, and sitting here amongst the five of us, you have probably over close to 200 years of energy experience sitting at this table. So I'm going to ask another question. Each one of you, you've got students in here that are coming out of the program. Employment is high. They're going into their different avenues that they want to go into. Each one of you, go down the line, tell me something that you think that you've seen now that they should be adding, if they were going to add an elective to their toolbox. What is that new toolbox? What's something that they need to add that would make them a better land professional in this market versus where we've been in all these years? Fred, you got any ideas?
Yeah, Mark, I looked at the curriculum. We looked at the curriculum yesterday. I think the school does a pretty good job of putting together a solid foundational base for these students. But if from my perspective, if I was looking at an elective, regardless of where you go in the land industry, at least as I can see it, understanding human behavior is absolutely critical. So I don't know whether psychology would be an allowed elective or some form of human behavior type coursework to understand, sometimes everybody in here that's done land work knows you're in a very contentious discussion with somebody. You find out, 3 days after you've gotten out of that argument, for lack of a better term, that what we were arguing about wasn't the problem. There was another thing. In a short example in mine, one of my mine operations, the rancher believed that our blasting schedule was affecting his lambing rates. I don't know whether it was or whether it wasn't, but he was not letting me move a pipeline onto his surface because of that. But he wouldn't say that while we were doing it. And it wasn't until 3 days later, I'm out there and he's dragging a dead sheep up onto the flatbed of his pickup, and I said I'd help him. And you seem to have a pretty high loss here. Once we had that conversation, I talked to our blasters. We changed our blasting schedule during his lambing season, so we didn't go into that pit for the 6-8 weeks that he was lambing. Fixed the problem, and I put my pipeline right through where it needed to go. So understanding that nuanced portion of human behavior, I think especially the students coming out now because of the COVID and the isolation and the Zoom classes, et cetera, a lot of that you would normally have picked up in college has gone away.
I know from AAPL's standpoint, because it's a constant level of conversation, but the most highly requested course to AAPL is in risk management and risk assessment. And I think it plays a major role these days in the fact that we're moving into the renewable arena. Because there's a lot of these projects, well, the majority of these projects are supported by federal dollars. And if they had to literally stand on their own, they may succeed or they may not. And that's a good thing. I mean, you need to be able to sort these things out. But to me, for Landman moving forward, you've got to be a specialist in risk management, because the companies you're working for, whether it's a broker or whether you're working direct for a major or something along that line, you've got to be able to give factual information and say, some of these things work, some of these things don't work, and we're not going to be able to do that. But the landman has to be a specialist in those areas. Mark, do you see anything from a geological standpoint or anything where that that you would say, gee, if you were going to go forward and trying to be successful, what would you add that you don't see now?
Well, the obvious answer from a geologist is to take an introductory course to geology. I mean, here we sit in one of the greatest geologic playgrounds. You can go out and see and touch the geology. And wouldn't you like to know more about it as you drive or walk? So take a geology course, an introductory course. Beyond that, in my career, a background in math and technical writing has been important. But beyond that, you have a tremendous opportunity to expose yourself to so many things here at the university. I am envious. And take advantage of that opportunity. And the bottom line is you need to develop critical thinking skills. And that will help you in your career. Critical thinking skills. When I was on the Oil and Gas Commission, that was my bottom line in taking testimony and questioning the experts. Thank you.
Jason, a lot of your work is in the same arena as visual as well as technical analysis. Would you agree that a strong basis in GIS coursework or things along that line would be beneficial to Landman, or do you see something else that you've seen over all these years that you go, I wish our students had more of this?
You know, Mark, it could be that we've spoken too often in the past. That's exactly where the thoughts would be. The ability more and more, and it's been there, we've all seen it for several years now, to take the data and be able to display that geospatially is very, well, it's indispensable, as we all know. Pictures are worth how many words? And so I have for many years now told students that, you know, they would be well advised to take, I don't know if they have to go the entire, you know, GIS tract of a geography type kind of minor, or how they get that ability. But whether it's a company, Landman, functioning as one of my clients in our relationship, or whether it's folks working for me, whether it's myself, I constantly find myself trying to conceptualize, because I don't have those skills myself. I have to conceptualize how things work, what the nomenclature is, and how to connect the two. And so it can be as simple as being you know, highly proficient in Excel and figuring out how all of that relates and operates in the GIS world. So yeah, technically, that's where I'd go, and I'll surrender the mic at this point, because whether it's communication, which is everything, or whether it's a few other aspects, to be a good landman, you have to be constantly expanding your well-rounded capabilities, and we could talk on that subject for hours.
Marianne, what do you see both from the corporate world to the renewable world? Is there something that you think current students could improve upon, or deficiencies that we should try and direct their education more towards to make them better professionals?
As, like I said earlier, a product of the PLM program, I have constantly, whether it's at Anadarko, Oxy, or now in my current role, the cross-collaboration with geologists and engineers, stakeholder relations, and landowners. I feel that this program has set me up for success. I can talk to geologists, I can talk to engineers, and not make a complete fool out of myself. I understand to a certain extent their business and the subject matter experts that they are. So I think the PLM program is doing an excellent job with that. As we all know, when you're dealing with land work, you're always dealing with an unknown variable, and that's the human on the other side of the table, whether that's representing another company or representing their farm or land that's been in their in their family for generations. So you never know how those conversations are going to go. So I would echo what Fred said, that maybe that psychology component would be very beneficial. I remember I took a negotiation analysis class here, and I thought that was excellent, just to give you an introduction to the different styles that you're going to encounter. I have worked a lot with mergers and acquisitions on the business development side. Maybe a class that discusses the mergers and acquisitions and provides examples of those types of scenarios might be beneficial. But as it stands, I can't say enough great things about the PLM program and the coursework that's laid out to provide a pathway for success for students.
The other one that I see, and I've just seen it in the 40-some years I've been doing this now, is we have gotten to an era where our communication skills are terrible. Everybody looks at a screen. Some of you are looking at them right now. No, I don't take offense to that. But the point being is that there's always this shortcut language to try and attempt to get to the end result. And although you think it's making you more efficient and faster and it's right at your fingertips and everything is there, the bottom line of what you've got to do is you've got to be able to negotiate. Landmen negotiate. And so remember that most of these old ranchers that you're going to go see to put your wind farm in or your carbon sequestration, these are probably good old hardcore 70-year-old ranchers. And they don't care at all about social media. So you've got to have skill sets that allow you to have not only creative writing skills, but take simple, if you're shy, take a simple speech class. Learn to be able to talk to people, because if you can't express your argument and convey the thoughts of your client or the people that you're working on, you're no use to me. You fail, and that you can be the most brilliant person in the room if you can't convey that argument and convince that person that what you're trying to do is, for their betterment and your betterments, the clients that you're representing, a win-win situation. You're missing the function that we're here for. So I would encourage you all to look at things like that too. Always work on creative skills, always work on speech communication, and the ability to assess what problems are coming in front of you at this point in time. To the table itself, we're doing a lot of work these days. It's shifted from a lot of companies into carbon sequestration, course-based storage leasing. Do we see these as being a continual, ongoing play for Landman for the next multitude of years, or what role do you see in the renewable energy is next? Where do we see that being a benefit to the students coming out of Wyoming? Marianne, do you got some thoughts on that?
Well, Wall Street wants to see oil and gas companies diversify themselves. And that's kind of the sexy thing right now for investors. So yes, I think it'll be a driver for decades to come. And you listen to any political debate or any politician speak, they're always talking about reducing carbon footprints and what that looks like for their agenda. And I think that we as land professionals will only continue to see more of that. And the beauty of being in the land profession is things change on a dime, and you have to be nimble and embrace new technologies, new innovations, new thoughts, new concepts. And I know that every student here will do that and do so with great success, but we have to think outside the box as land professionals and adapt with whatever Wall Street wants, whatever the political environment calls for, and whatever being a good steward to the environment looks like at the time.
Any of the rest of you have a thought on that?
I'll chime in. As far as the carbon capture and underground sequestration, I think that has the potential to be a ongoing like oil and gas. The political climate, the actual climate itself is somewhat driven or driving that towards that direction. Granted, on a global scale, it doesn't make a whole lot of sense for us to pump down and shut down coal when India and China are building as fast as they are. But I see, at least in our world, where we work as landmen, I don't see that slowing down. I see that actually growing. What is it? Correct me if I'm wrong, Mark, but North Dakota and Wyoming are the two that have codified pore space as being part of the surface ownership. I see the other states following along, and I see that being a unique puzzle piece for the land professional going forward in the next, 5 to 15 years. That will get straightened out. I don't think you'll ever have a producer's 88 for CCUS, but I'm pretty sure you'll come up with something close to it.
We've had, Wyoming has in its renewables, we're obviously working towards hydrogen, ammonia, some of the other carbon captures. We've had wind forever, and some of the various biomass types of things. Do we believe, and Mark, I guess bring this question to you from your time at the Oil and Gas Commission or from the commissions in general, do we see an industry such as solar? Texas, is huge on solar energy, which is another major component. Most of the new landmen that come into AAPL out of the Texas region are working on wind and solar projects. Do you see those other commodities like solar and stuff as having a place in Wyoming's long-range renewable portfolio?
Sure, it has a place. I don't know what kind of place, how much, because I've seen across the U.S. estimates that renewables are going to peak out at 20%, and others, like in the Biden administration, say they want 100%. So what is the number? I don't know. But renewables are very land intensive, and that's something we need to look at. My time at the Nature Conservancy, I've seen TNC, the Nature Conservancy, look at disturbed areas and maybe using those for wind and solar farms. I think that's a great idea. So use the disturbed ground, disturbed from coal mining or other activities, and repurpose that to renewables. My concern about renewables is that it's very land intensive, and I'll give you an example. We all know the Jonah gas field, and just south of that is the Sweetwater Solar Farm, and I supported that development of Sweetwater Solar. I gave them an easement. I could have potentially blocked it, but didn't. More power to them. So the disturbed area of Jonah is 2,000 acres. Now, I'm careful to say disturbed, not affected, because affected area would be greater. Sweetwater takes up 1,000 acres, so it's half that. But when you normalize the energy generated in those two projects, normalize it to BTUs being generated, and you can do that mathematically. It's pretty simple. Sweetwater, Jonah Energy produces the same amount of energy as Sweetwater Solar every 3/5 of 1 second. We'll let that sink in. Every 3/5 of 1 second. That's Jonah Energy's production as compared to Sweetwater Solar, and Jonah runs 24/7. So, in order for renewables to be totally effective, you need to take up huge amounts of land. And I, for one, renewables have its place, but there's a limit, I think.
Okay. Mary Ann, I just read an article here recently talking about wind generation. And it was interesting because it takes so long to permit a wind project. It's very cost intensive on a front end load. And then oftentimes you see the turbines out there starting to spin and you think, okay, we're generating power, but really the article was saying that we really aren't, because the next step is you've got to go through the whole transmission situation. And by the time you get in the power grid and the transmission and hook them up, that wind generation could actually take 8, 10, 12, 15 years to become economically viable in that particular thing. Being that you're working on the renewable side these days, do you see things that are impediments to further renewable development such as that? And do you have any ideas at all as to what the state might look at or the university might look at as far as something to, if we're going to go down the path of a renewable energy portfolio, how do we actually make the best mousetrap out of that?
I think the biggest hurdle right now for the renewable industry is the infrastructure. The grid needs an overhaul, not only from like a national security standpoint, but also you can lay down as many solar panels or wind farms as you want, but a lot of the times we do not have the capability to transmit that energy that is either stored or produced. So that's a massive issue right now that I know people in a lot higher pay grades than myself are looking at and trying to determine the best solution. At one point in time, oil and gas wasn't as efficient as it currently is today. I think renewables are going through a lot of growing pains right now, and I know that there are brilliant minds working on trying to reduce the footprint of solar panels or big wind farms, make them bladeless or whatever it may be. And I think that we're on the forefront of maybe breakthroughs in that realm, because yes, the footprints need to be smaller and the infrastructure with the power grid needs to be updated, improved. That way we can capitalize on the energy via the renewable side.
You brought up an interesting point there of bladeless wind towers. I mean, that's one of the #1 complaints of the damage to raptors and all the other things that happen with that. Do you see that as being, are companies really working towards that, a bladeless type of system? And if so, is that something we might see over the course of the next 5 to 10 years?
I can't tell you what university because I don't have it on the tip of my tongue, but there are universities that are studying bladeless wind turbines and what that can do to overhaul what we view as the traditional wind farm. And yes, I think that would completely change the game and make it more appealing for landowners to possibly want to elect their land for that, and allow renewable companies to stack so much more infrastructure into a smaller area that it would be beneficial all the way around. And I think we will see new technologies like that emerge.
This ends the prepared questions that the students had provided to us that we wanted to talk about today. We've got a few minutes left. Are there any other questions from the floor that this panel could address? Yes, sir.
Thanks to the panel. Do you think this profession has any role in helping conservation initiatives, such as protection of migratory animal corridors?
Anybody want to wade into that? Mark?
Larry, I think it comes to what is an appropriate site for these different forms of energy. How do you prioritize? I gave you an example of TNC looking at how disturbed areas might be repurposed. TNC and others are also looking at migration corridors and how to preserve them. So, yeah, I think there's a great role for this student body.
I was thinking on that, the two things that came up, Larry, when you said that was You think about things like sage grouse mediation. Companies are obviously actively working on things along that line. I think the biggest avenue is self-built into it. In other words, development of any project right now has to go through the NEPA process. And where you're seeing a lot of those types of changes coming is what's happening in development, in the further development of the NEPA process and coming along with that. Does Alpha Oil Company sit down and figure out how to best deal with, a wildlife corridor or something along that line? I'm not sure that's their first thought, but it's a thought in the overall process because it's required under documents such as NEPA and other things along that nature. Could we do more? I'm sure we could, but then you have to balance all of the regulatory. We can get to a point where we balance regulatory and the good things that brings to where we literally stifle the creation of that particular industry. And so how do we get it so that we can still work and perform, but yet maximize that rate of return?
Mark?
Yep.
If I may, one more thought. I think there is a role in trading credits, and John, you brought this up at the break, and I blanked on it, but credits can be exchanged. If you have a project, say a natural gas project like Jonah Gas has in the heart of sage grouse country, and you're affecting sage grouse habitat, you can buy credits from Sweetwater, a bank, a credit bank, and preserve habitat in one area to offset the disturbance in another. I think there has to be more of that.
I agree. Anybody else have a question for this panel? Yes. I think the other thing too, and I want to pay a compliment since I'm kind of at the end of my term for what I've done, and I started as Jake did when this program was originally created. But this university is brilliant when it comes to advancing thought in the energy profession, and it's highly regarded around the country. The other comment that I would make to the Landmen that are taking coursework in this particular area, I was thinking the other night, if I was 40 years younger and could come back and do additional studies here, there are all types of certificate programs that the school is developing. School of SER has. There's things on renewable certificates and on GIS mapping, if I remember correctly, and is there another one that we have besides that, Cami? The CUS. And so, what I would do if I was coming in here as a new student, no matter where I wanted to take my professional career, I would take every single one of those certificates. I would design my electives around maximizing those returns. And the reason is, and it's what everybody has said here, whether you're talking about another tool in the toolbox, or I used to use the phrase another quiver, you know, another arrow in your quiver. It gives you exposure that brings you out into the business. We heard yesterday that there are some people that have taken this GIS certification. It's not that difficult. It's 3-4 classes or something to get the certificate to it. They were employed because they had that skill set. And so you want to make yourself available across the board. This university does wonders in that particular level, and you should always be taking advantage of it where you can. Any last questions? We're just about done. Yes, sir.
For Mary Ann and Jason, as a traditional oil and gas field landman, I've recently been trying to gain new skills and experience in the renewable field. And what I've come to understand and what I've experienced so far is the pay gap between oil and gas and renewables is almost insulting. Do you see that ever catching up and becoming commensurate?
Yes, I have seen that, and when we are looking to have like boots on the ground, find a land agent or landman that can take solar leases, for example, I know that with my short tenure with Western so far, we've already had to increase our day rate because we've seen a lot more just demand in getting good agents, and I think that that's only going to increase. A lot of our land agents do not have a lot of renewable experience, so they're pretty green right now, but every day as new projects come on our table and other companies' tables, that's going to change. Everyone that's out in the field getting solar leases, they're adding more and more value to their own skill set and then to potential employers. But yes, that pay gap needs to be bridged, especially if we want good, talented agents out there. And the federal dollars are there. I just think that we just need to keep advocating for ourselves and our profession, and recognizing that renewables, it's not going anywhere. It's only going to become more prevalent, I believe, and knowing what our worth is, and that we do bring a lot to the table regardless, because so many of the skills that we learn in oil and gas is transferable to the renewable field, that yeah, we bring a lot to the table and therefore should be paid appropriately. So I'm hopeful that it'll get better, but I don't know when.
I think the answer to your question too, and it always has been in the 40-some years I've done oil and gas work, it's a supply and demand issue, okay? A lot of people went into renewables and started doing renewable land work because they couldn't find conventional oil and gas work to do. They had the same skill set, but they didn't have that. And so the reverse of that problem is, think about it right now, as busy as the general oil and gas industry is, and as busy as renewable energy is, okay? If we were to add something new, let's say the shale play starts again tomorrow. Okay, here's my forecast. There would be no one working in renewables because everybody is going to migrate to where the higher dollars are. And that's just the up and down of the industry. Will it get stabilized at some point in time? Sure. But the only way that we can do that is by generating more and more landmen to counterbalance that. As they can get more people and the industry gets stronger, the better the pricing point comes. With the newness of the industry is also part of the reason why it's limited at this point in time. But I mean, if a conventional oil and gas company walked over to you after this session and said, I'll pay you X number of dollars a day to do that, you'll have to decide whether you're doing renewables tomorrow or working conventional oil and gas. Okay. Anything else? Anybody else have one? The one final thing that I would tell you, and it was a question that came up again with Jake's about ethics with if you're not a member of AAPL. AAPL is an industry leader. They are described as the standard for land practices. Do you have to be an AAPL member? No. Is it beneficial to you in certain arenas and things along that line? Yes. And one of those arenas is education. So if you want to learn about solar, if you want to be a better renewables landman, they have entire web courses. You can do it all from your computer, and you just get those extra degrees, those extra arrows in your quiver by learning to do anything that you want to do. The fundamentals are there. All you got to do is look and explore for it, and you can do it. I want to thank this panel very much. These are people that are leaders in their particular professions, and they've given their time and energy to you, and we appreciate your time and energy with us today. Thank you.
So next we have a highly anticipated presentation from the BLM. Today we have Dave Chase, who is the Chief of the Reservoir Management Group, RMG, for the BLM in Casper. He is responsible for the following BLM programs in Wyoming: unitization and communitization, drainage, gas storage, Indian diligence, and reasonable foreseeable development scenarios for NEPA documents. Dave will be joined by Bill Beck. Bill Beck is a licensed geoscientist with 20 plus years in oil and gas exploration and production, petroleum program and project management, seismic data processing, geophysical reservoir characterization in a variety of geological settings around the world. Bill and Dave, the stage is yours.
Thank you. Okay, perfect. Before I start off, the BLM was contacted to give maybe a couple presentations here. One of the talks that I always do is on oil and gas agreements, exploratory secondary agreements, but with the shortage of time, I just took out a portion of the presentation that I do. So I apologize up front because it's pretty specific to what we're going to talk about. Without any background with oil and gas agreements, it's going to maybe be a little tough to follow. In my capacity being a supervisory petroleum engineer for the Reservoir Management Group, I deal mainly or mostly with Landman from oil and gas exploration companies. So if you do work in the oil and gas industry, the major part of as far as working with the BLM, if you're a land person, is going to be with these agreements. And I don't know if there's any courses that are taught at the university or that give a little bit of background on agreements or not, but just to let you know that it's going to be pretty specific today, but they asked me to kind of talk about how we work with horizontal wells in these exploratory agreements. Am I going to shift these myself? Oh, here we go. Okay, so just quickly, these are the agreements that are approved in the different states. You can see that Wyoming has the majority of the agreements, and they're broken out to exploratory, secondary, and then API type units. But just a slide to give the relative number. I think Wyoming now we have around 550 exploratory and secondary units that we administer. So, like I mentioned before, now we're going to talk about fairly specific requirements, or I shouldn't say requirements, but the type of unit agreements we're seeing now are for exploratory units for horizontal wells, typically in the Powder River Basin area. So just as an introduction, these are the 4 topics that we'll talk about today. So obviously before the maybe invention of horizontal wells, the type of wells that we had drilled in units were vertical wells, obviously. We had a lot of experience, and there's way more agreements that have vertical wells and horizontal wells. It was around, say, 2010 when we first started seeing our first units approved for horizontal wells with Chesapeake here in Wyoming. So to distinguish between a conventional play and an unconventional play, you could theoretically have a horizontal well that's drilled in a conventional play, maybe across the top of a structure where you could contact more formation with the horizontal well. But more than likely, you're going to see situations where, you're going to have an unconventional play, and it's really a horizontal well, probably drilled in a shale formation. But we've expanded that definition to include almost any horizontal well, whether it's drilled in a shale, a sandstone, and it would fall under this unconventional play. And there's some benefits you get when you set up your exploratory unit having an unconventional type play. So just a definition we don't need to go over. We've actually taken that definition, like I said, kind of modified it a little bit to allow almost any horizontal well to be drilled in Wyoming as a unconventional resource play. So some policy we have specific to the Reservoir Management Group. Exploratory units, we won't approve them larger than 25,000 acres. And if you think about it, an area of 25,000 acres where the drilling requirements aren't that strict, it's very difficult to develop that entire unit area over the life of the unit or the time that you have to drill in that unit. So we're holding unit agreements to 25,000 acres. It's not a regulation, it's just a policy that's been used for years and years. And then just quickly, since we cut off the a unit agreement with horizontal wells on actual full sections, you could conceivably have a unit that's a little greater than 25,000 acres. And then we proved, back in the mid to late 90s, maybe early 2000s, we approved probably 35 to 40 coal bed methane or coal bed natural gas units. We had the same requirement, 25,000 acres. If you think about it, that coal bed reservoir would have extended throughout the whole Powder River Basin, but we still limited the units to 25,000 acres. Probably more importantly, when you have a conventional type unit agreement with vertical wells, typically that unit agreement is established based on some kind of geologic play, structure, stratigraphic trap, whatever. With the unconventional exploratory units, like I mentioned before, you may have a formation that covers the entire Powder River Basin. Obviously, we're not going to approve a unit that's hundreds of thousands of acres, but what we do allow is we do allow the operator to pick and choose the acreage that they want to include in that unit agreement up to 25,000 acres. And that way they can get that percent that they need for that unit to be formed. And that was the difference between the horizontal or the unconventional play and the conventional play units with vertical wells. And then we have some requirements where that initial obligation well needs to be located. It needs to be located a mile away from the unit boundary and then a mile away from any penetration to that formation. If you think about it, a 25,000 acre unit, it shouldn't be difficult to actually locate a well with a 2-mile lateral that would meet those two requirements. And other states may not have requirements like this. This is specific to Wyoming. And then we like to see that, if we're approving these units that have 70-80% federal acreage, we like to see the majority of the lateral intersect federal minerals. But we know in a lot of instances it's tough to drill a 2-mile lateral where you're only going to intersect maybe federal minerals. And then the requirement, we do have a requirement when a unit's formed for the unconventional play, the unit agreement's established where the operator will drill a 1,500-foot lateral in that formation horizontally. But after that initial obligation well is drilled, the unit operator now can drill anywhere in the unit to any formation that they want to. They can drill vertical wells now. They can drill horizontal wells to deeper, shallower formations. So we just have that requirement we talked about. Excuse me, it's only specifically for that initial obligation well. So here's an example of a well or a exploratory unit that was formed just east of the Salt Creek field. You can see the boundary doesn't, it's not really set up for like a geologic, actual geologic structure or prospect. Excuse me. It's set up on the unit operator's lease plate, which should be in the yellow. And then looking at the area that they could drill, where it'd be a mile away from the unit boundary and a mile away from an existing penetration, you have that little red envelope area. The lateral is planned right there, so it met the requirement to drill a well. Like I said, it's easy to find, or most of the time it's easy to find a location that you can drill to meet our requirements. I mean, theoretically, being an unconventional type reservoir, they could have drilled up in this area here, but you still want to drill near existing well control. Like I mentioned before, the only requirement we have besides drilling the well in that formation is that the lateral needs to be 1,500 feet. And now with the laterals drilling 2 to 3 mile laterals, the 1,500 feet may be a little low, but we just haven't ever changed that requirement. And that gets a little more specific about when the unit's validated, so we don't necessarily have to go over that item. Now in the unit agreement for vertical wells, the important thing is the part that's in the blue, where for a vertical well, the requirement was that the well had to be drilled to a certain depth or so many feet below top of a formation. Well, obviously, for horizontal wells, that requirement didn't make sense, because now you're drilling a lateral, and you don't need to have a depth requirement or so many feet below a formation. So in this case, the only requirement was to drill a horizontal lateral, in this case, the middle bench of the Niobrara Shale, of not less than 1,500 feet in length. So this section 9 is part of the language in the unit agreement. So we did have to make some modifications to the unit agreement to handle horizontal wells, because initially the agreements were all set up for vertical wells. So once that unit agreement's approved, the unit operator has 6 months within which to drill their initial obligation well. So obviously the three outcomes for drilling a well could be a dry hole. Let me see if we talk about quickly here. Okay. You could have a dry hole, and now what would be required, and it's really tough if you think about it, to drill an actual dry hole in the Powder River Basin. I think it may be seen it for 1 or 2 exploratory type units, but the majority of the wells drilled horizontally are going to produce some oil and gas. But if you did drill a true dry hole, you now would have 6 months 6 months from the completion date of the first well to drill your second well if you want to perpetuate the unit. Obviously, any lease in the unit is not held by production because there is no production. So the second scenario, you could drill a well that has production but is considered a non-paying unit well. After a period of time, we look at the production. Unit paying well means that the well itself will pay out the drilling and completion cost for that well. Now we're getting real specific when we start talking about drilling a non-paying well, and what we have, leases are going to be held by production based on this Yates determination. It's based on a IBLA case back in 1983. But what it does extend the leases themselves by production, even though a well was drilled that was a non-paying unit well. So probably more importantly, get to the point where a well is drilled, it's considered a unit paying well. And now what we do is we have the well payout, its drilling and completion costs, but now we need a way to allocate the production, the cost, and more importantly, the royalty for that particular horizontal well. So by definition in the unit agreement, the participating area is the area reasoning proved productive. It's not necessarily the drainage area of the well. It can be determined the participating areas. I'll show you in Wyoming, the method we use, it's different. What they use in New Mexico may be different than what they do in North Dakota, but at least here in Wyoming, we use this circle tangent method, and I'll show you how that works. Circle tangent method can be used for vertical wells just as well as horizontal wells. And it was simple, equitable, and it's well accepted by industry as far as Wyoming's concerned. Okay, so instead of reading this entire slide, we can look at a diagram here. So in this case, horizontal wells drilled in this smaller 9-section unit. To determine that area, the participating area, what we do is we draw a 40-acre circle around the bottom hole location of the well, and then a 40-acre circle where the lateral actually intersects the productive formation. So if you kind of picture the well being drilled vertically and then working its way horizontally, it's where it intersects that formation that's productive. At that point, we draw our other 40-acre circle. Then you'd connect the two circles with tangents, and then we'd look at all 10-acre subdivisions cut by the circle and tangents, and that would be our participating area boundary. So once we have that participating area boundary, we actually give it a notation and then an effective date. So what's that participating area boundary mean? Like I mentioned before, it's the area that is determined for, I mean, as for the BLM's concerned, for the royalty payments. For industry, it could be how the working interest is divided, plus how the royalties will be paid. So in this example, 380 acres, you can look at the different mineral ownership, and that's the breakout between fee, state, and federal acreage, then percentages. So now if that participating area well made 10,000 barrels during the initial month, so May 2010, you have your breakout between the fee, state, and federal percentages. And then if you do the calculation quickly, royalty would be owed on 756 barrels for that month times whatever oil price you would have for that month. So here's an example using that circle tangent method. And in the past, we had the operator put together the proposed boundary, send it to the BLM, we would review it, send it back to the operator if we needed any changes. So we changed the process where the BLM will construct that proposed pay boundary, then we send it excuse me, to the unit operator to see if they're in agreement with it. So in this case, we have, if you can see, we have 2 wells drilled off a pad right down here. The first well was determined to be a unit paying well, so that initial PA boundary is kind of outlined here in the, the dark blue. And then, so the operator submits their Exhibit A that shows the boundary, it shows the tracks that are going to be included in that participating area. And then what we have is we get a Schedule B, and the Schedule B then will list the tract number, the lease number, description, acres, and then probably more importantly, it'll list the participation for that particular tract. And then we just summarize it down here. So for the, at this point when this PA is approved, 25% of the royalties paid to the federal government, and or 23%, and then 76% would go to fee mineral owners. So in this case, off that pad, a second well was drilled. It was just completed in a different month than that first well. So now we're going to revise that initial participating area to include the production from that new well. So once again, the operator submits a new Exhibit A, which shows now the PA boundary, and along with that Exhibit A, they'll show another Exhibit B, and in this case, we have the same 4 tracks, just a coincidence, but you can see that obviously the land description, the acres are different, and then that participation is revised. And that revision will be effective typically the first of the month in which that knowledge is obtained that we do have this paying well. So now what happens is we went from a little over 23% federal participation to 22%, and now the fee's almost 78%. And once again now, if a 3rd, 4th, 5th well are drilled, we can continue to expand that participating area until such point as they don't drill in that unit anymore. So then quickly, you can have a situation now, if you think about it, let's say you drill your unit well, and it's determined to be a non-paying unit well. You still need some way to allocate that production to the different royalty owners. So what happens at that point is, okay, so here's an example of a well drilled from a state lease to a federal lease, determined to be a non-paying well. Now the unit operator needs to file an application with the Oil and Gas Commission to establish a drilling and spacing unit. Once that drilling and spacing is established by the commission, then the operator submits a communitization agreement to the BLM. We approve the communitization agreement, and that communitization agreement will lay out the allocations to the different tracts, just like we did with that participating area. And then now for royalty payments, if you think about it, if a well's drilled and it takes the BLM 3 to 6 months or longer to determine if it's a paying well or not, what happens to those royalty payments that should be made or may need to be made during that time the well's producing, but a PA or a CA hasn't been approved? So if you're in a fed situation, which means if the well was drilled with fee surface, fee minerals, and then it does intersect, say, federal minerals later on in the lateral. Oh, that's how that did that. Okay. Now, it's my understanding, which I just learned recently, is that no royalty payments would be due to the federal government until such time as that CA or PA is approved. And as far as paying the mineral owners, I think each operator does it a little differently. They may wait till the CA or PA is approved, then they know what the allocation to those different fee tracts are, and at that point, they would pay the mineral owners. But in the other, wow. I should have looked at that and how the horizontal wells thing came in, but that's all right. So now if you have a situation, let's say it's fee fed, where fee surface federal minerals are below the surface, in those cases, 100% of the royalties are paid to the federal government based on the first lease that's completed, federal lease that's completed in that lateral. So then obviously it's important for the operator to either get that communitization agreement or participating area approved as soon as possible, because they don't want to pay 100% of the royalties to the federal government, knowing that once the PA or CA is approved, it's probably not going to be 100% federal participation in that PA or CA. Okay, so that covers that portion. I know it was quick. I know, once again, apologize without the background with agreements. It's probably fairly tough to follow. Is the other one set up here? I wonder. Is there any questions then? If I could ask them at this point. Are there any questions anybody has? Yes?
What's the working interest of approval for an exploratory unit? Is it 80%?
So to get approval, it's 85% of the tracts committed, you need committed to the unit. So then just quickly, you think, well, shoot, 85%, that means if an operator has 90% of the working interest in the unit, they should be able to get those tracts committed. They have 90%, the requirement's 85, but you have to look at it a track-by-track basis. So you need 100% of the working interest owners for that particular track to ratify the unit agreement so you can get that track committed. So if you have 99% working interest throughout the unit and you have one party that has 1% and you can't get them to ratify the unit agreement, that unit agreement will not be approved. So that's how the 85% works. Any other questions? How much time do I have? Am I doing good? You're doing great. Okay. So, did I put that other one on? Did you get that other one? We're doing that afterward? Okay, never mind. All right. So now, Bill Beck, then we'll talk about the 7 IMs that were issued by the Washington office near the end of the calendar year. And so he'll briefly go through them. Most of them deal with the new leasing changes that were enacted by the administration. So, Bill?
Thanks, Dave. So I've seen various versions of this presented. Was anybody happen to be at the foundation presentation that put this on? Okay, I'm just going to give you a caveat. I'm not nearly as well spoken on this subject as Peter Cowan or Nada Culver. If you were in Moreland last week and attended the oil and gas outreach meeting we had up there, I'm probably going to be a little bit better spoken this time than I was up there. So somewhere in between, you'll get a good presentation. First, kind of put things in a timeline, sort of a timeline context in general. Obviously, with the new administration, we had a new look on leasing. In November of 21, we had the report on federal oil and gas leasing that came out. Kind of was not so favored by industry. That was followed up by the Inflation Reduction Act, the IRA, and that had a lot of changes to how we do leasing. And so these IMs are basically they're kind of giving us a policy and procedures to follow follow the IRA, but they're influenced a little bit by both. And let's see if we can get started. So what I want to do is go ahead and give you these are the list of the IMs. For the IRA, you have the IM 2023 6, 7, 8, and 10, and then you have some other IMs that affect other parts of leasing that we'll talk about. And as I stated, the guidance that we had for these IMs come from the IRA and then also from the November 2021 leasing program report. Let's see. So one of the things to do is see how they all relate to one another. You have IM 6, which deals with expressions of interest. So operator says, hey, I got like this chunk of land. I'd like to get a lease over it so that I can continue to explore and produce, hopefully produce from it. These instructions will give you, this instruction gives us policy guidance on how we accept IMs, some boundaries and conditions on how to accept the EOIs. The number 7, 007, we like to affectionately call that the James Bond IM. That one gives us guidance on how to conduct the qualifications of a parcel to take to a lease sale, and then also some of the follow-on guidance on how to process it, the EA as well during the lease sale. Those lead into IM 10, which talk about one, making sure that we follow the guidelines from the other IMs, but also the most important thing that's new to the process is it formally brings in the scoping period that precedes the public comment period, which precedes the public protest period. So we have another public commenting period that we invoke. So that's the path in the leasing. If you look at the leasing timeline, 008 just kind of revisits the guidance from the IRA, and then that influences the 01010 IM, and then it also influences the 09 IM, which directs mostly to reinstatements. There are two other IMs that are kind of a little just kind of hang out there on their own. IM 11 talks specifically to APD extensions, so approved permits. And then 12 talks about something where Dave and I kind of intersect every once in a while, and that's on the lease suspensions. One other person that at the BLM that's not here today with us, but is an integral part on this team, is Sandy Blackburn, is our branch chief for adjudication. So I would be speaking for her on the parts on the EOI. So there's that. She's the missing piece today. As we go through, it's kind of good to look at the IRA section from the law, and so. The key thing to take away from here is that oil and gas leasing basically opens the door for renewables and projects to go forward. And the key for that is going to be making sure that we have 2 million acres and 50% of the acreage for which the expressions of interest have been filed. I did take a key note from one of the presentations that Nada and Peter delivered, that it's the number of acres, not the actual specific acres that are have EOIs on. So you may have an EOI for whatever reason. It may have issues getting processed or whatnot. And there's a lot of conditions that we have to look at before we can even begin to process the EOIs to make sure they're ready to go. So if we jump into 006, we take that concept of 2 million acres and 50% of the EOIs. And have a what some people may call simple. Mark's not here anymore, but I'm a geologist, and my background looks at math with very nice numbers and variables. I'm not used to large word problems like this. But basically, it's the number of acres offered in a year have to be greater than the number of EOI acres submitted in a year times 50%. So it's just basically half of it. Let's see, so the other thing too on this is that we have to have those EOIs are summed up over each quarter so that we can bring them to sale and those add up. Okay. Then there's some guidelines on how what we can not calculate, what we can and cannot calculate for those EOIs. So one of the key things to look at here is deferred by court order. And we go back and look at the context of where these are coming out in. Specifically, as it affects Wyoming, there are a number of court cases that have locked down a lot of our leases in terms of what we can and can't do. We're hoping to get through those. We seem to be making some progress in the courts, but I'll leave that to the courts and the folks at the Department of Justice to help get that sorted out. Yep. And it's kind of normal stuff that you want to make sure is not done, like the acreage isn't already leased. Surprisingly, we get quite a few EOIs where the acreage is already leased. And then also making sure that the BLM is actually able to process the EOI. This was the list I was thinking was next. And so other reasons that we cannot, or that we would remove acreage in the submitted EOIs for lands that cannot be offered, or if they're in one of the statuses. So if it's already deferred, this next one seems kind of silly, but it actually happens quite a bit. If the parcel in the area of interest, or area of expression of interest, is already a duplicate parcel. So a lot of times we need to sort those out. Again, we talked about that already being leased. And then the other part is unable to process the EOI. And there's lots of, as well as listed here, lots of reasons that can not allow a process to be parcel to be processed. Surface owner issues, whether it be, you don't have the information from the surface owner. The acreage doesn't have federal mineral rights. The surface owner has withdrawn their consent. And then also, obviously, any of the existing environmental conditions, such as a wilderness study area, a national conservation area, we can go ahead and work those out. Okay. So that's the adjudicative side, and this would be what Sandy and her team work on. When you get to the IM 007, the James Bond IM, this gets to where what my team work on. In 007, there's a table. It's actually kind of convenient. It walks you through 5 different categories. One, they want to be proximal to existing oil and gas development. I think that it says 5 miles or whatever a prudent operator would consider developing. And then we start talking about the habitats and connectivity corridors, cultural resources, and then minimizing conflict with resources in the surrounding area. And then finally, getting into how you would develop it. So is this a parcel that you would be able to put in a well or more on the parcel? Oh, yeah, there's one more slide on that. And so how we evaluate those parcels, using those criteria. We also look at existing law, regulations, and policy governing oil and gas nominations. We also look to close out EOIs that are over 3 years old. That was a bit of a question early on. So we've got most of those going through the system. Prior to the enactment of the IRA, those parcels are still, I think we've got through all of those already, so we should have those already in the system in one of the coming lease sales. And then finally, the use of NFLSS, the National Fluid Lease Sale System. I forget what that second S is for off tonight. So if you're any of your operators can go in there and keep track of the EOIs that you've submitted and see where it is in the lease sale process. I think it's a good point now to go ahead and talk about the process itself. We plan on a 10-month process for sales. As you may or may not know, we currently have 3 sales in the process. We've just come back from public scoping on a June sale, so that one's come up pretty soon. We've gotten public comments back on a fall sale, Q3 sale, and then we went out for scoping on a Q4 sale. Let's see. Okay, yes, that part. So moving on to 008. This is basically kind of to rehash all of what was discussed in the IRA and codify it for folks. Those terms were the royalty, which is at 16.67%, and then also the rentals went from $3 an acre, or $3 an acre or a fraction thereof for the first 2 years, $5 an acre or a fraction thereof for lease years 3 through 8, $15 an acre after that. The minimum bonus bid was raised to $10 an acre. The EOI is what's now at $5 an acre. And then class 2 reinstatements, and then also the elimination of non-competitive leasing. Right. So the other part of 008, we're also gives the BLM offices the tools and procedures that they need to follow to help process a lot of this information. For example, updating leasing forms and things like that. Getting back into some of the stuff that Dave does, it also gives us guidance on how to apply the royalty rates for new leases or CRAs, and then also for unleased land accounts, how to apply the royalty rates there. I think we moved to 10, yes. Okay, and so for IM10, going forward, the big addition here was the scoping period for a minimum of 30 days. So we've seen that in each of the sales that we've had, including the sale we had in June of 2022. And then also it just codifies the need to follow the 007 and 006 IMs. Yep. Also, it gives us leasing on guidance on how we issue leases within 60 days from the sale, and then also gives us some more tools to make sure that gets done, and also to get it uploaded into NFLSS. Right. So 009 addresses reinstatements. And so for the reinstatements, the biggest thing is that the public is about public interest and making sure that we're doing it, reinstating leases with the public interest in mind. And the other big part of this is that we're basically following all of these are very similar to you. If you read them out, they should look very similar to the 007 IM. Let's try something different. I'm naturally right-handed, so it's just kind of been awkward. Let's try something, see if this works any better. Okay. Also for 009, the additional improvements for reinstatements, it gives guidance on making sure that the governing laws and regs are followed. It gives us a checklist to use when there's a petition for reinstatement, and then also more templates and guidance for us to process those reinstatements. So moving on to 11, which is the application or APDs, approved APDs and extensions. Again, the main thing was we want to be within the public interest. Want to make sure that we've visited all the impacts that may be affected by the extension. Make sure that if there's any additional NEPA that will need to be required because of the extension time changing. Make sure we have all the governing regs to make sure that also that the bonding's still sufficient and that the entity applying for the extension hasn't managed to get on the 17G list, which is the list of entities in non-compliance. At the end of the day, this is really just kind of cleans up that whole extension process. There's a lot of gray area and kind of blue space. This kind of gives clear direction as to how we should do that, manage the extensions for the approved APDs. Yep. Oh yeah. So the also gives us the requirement to only extend the approved APD within 3 months of the original expiry. So we won't process the approval for APD extension unless the original APD is in the last 3 months. So that's kind of an important timeline thing. And it also limits the extension length for how long we could do to make sure that it's appropriate for whatever the reason is for the extension. But we also, while we should not approve more than one, I've been told that on various occasions there may be situations may warrant other extensions. Let's see. Oh yes, and then the extensions also need to be consistent with the timing requirements for a CX if that's appropriate, and then also just make sure that the BLM is entering all of that information into AFMIS. And so for suspensions, this is the last one. This gives policy for how to review those requests for suspension for operations or suspension for operations and production. Basically, the idea here is it gives guidance on the Section 39 and Section 17. It reminds offices that requests must be executed by all operating rights owners, so make sure that everybody is operating on the lease is on the same page. And then also just make sure we're addressing all the issues that would be outlined in our handbooks and guidance. And then lastly, yeah, so this is the part where we talk about suspension as it relates to timelines for APDs. Make sure that we consider all of suspension during that the considerations for suspensions are based on leasing delays are also considered. And then also termination of suspensions are in terms of a definite term, so not like indefinite suspensions that would last a very long time. With that, are there any questions on leasing? He's right there.
because there's like nobody outside of myself that could do it, and I don't want to. No, I don't. No, probably not, because if you think about it, we have the manual and handbook section on agreements is from, what, 1993 or something, so probably not a big hurry since it's been 30 years. But I don't know if a lot of the unit agreement, it doesn't, it talks about general terms, and it talks about follow the existing regulations, so a lot of it probably would take into effect some of the changes anyway. Maybe with horizontal wells, there's some sections that could be written maybe a little bit better to cover situations that that we have with horizontal drilling that the unit agreement doesn't cover, but probably no. I just don't think, well, even those little sections, because we're not sure like what level we'd have to take it to get it any changes made, so unfortunately.
Yeah, with the addition of these 7 IMs that they've recently issued, it appears at a high level your workload is going to be increasing. In the IRA, do they provide additional funding, or do you have the current staff you need to meet the IM requirements?
So far, we're kind of testing that out currently as we speak with the 3 sales going through. It's the best way to test policies to actually have sales occur and figure out where the strengths and weaknesses of the sale are, the leasing process are. One of the things that's kind of holding us up a little bit is on reinstatements, because we got a lot of conditions in the courts right now that kind of really kind of hamper us a little bit when getting those through. So things like that are a little bit hesitant on the APDs. I don't think that should affect us in terms of staffing. Whereas there's a lot of workload in the sale process, we've opened up that timeline. That's in accordance with the previous leasing IM, which I believe was 2021 or 2022, 027 was the number, where it basically gave the state offices ability to define our own timelines and processes. So far, no. Let's see how it goes when we get up to sales, and hopefully you guys are with operators that will continue to lease, and when we start getting in sales where there may be 300 or 400 parcels nominated, that'll be a real test. Right now we've only had maybe 200 was the highest so far of the 3 sales. Like I said, when we start doubling that or maybe even tripling that as in the past, that'll be the real test.
Steve.
Yeah, I had a question to go back to 007 and the lease deferrals. And it's just because the one lease that's been conducted since Biden took over, and then the next 2, the state office has deferred close to 50% of the proposed tracts that were available for leasing in the local resource management plans. After you at the state office have deferred 50% of those lands, are you sending that guidance back to the field office that those lands are no longer available for lease despite what the resource management plan says?
Yeah, so one of the other important parts of the 007 IM does it changes the terminology from defer to preference. And so our preference for the 3 sales that are currently ongoing was to put a lot of those leases back into the evaluation pot, just to make sure that they're that we can, if there's any way that we can actually, whatever reason we put them in the low preference to get them into the high preference. In the 2022 sale, those were deferred. We were kind of coming into that sale without the guidance of these IMs, and so we're trying to figure out what we were going to do with leasing. So our preference was, at the time, preference was to hold them off, especially with the ongoing court cases involving sage grouse, and then also with the development of our new sage grouse policy that's hopefully working its way through the system now. So there are other cases where there were, where the deferred parcels were just deferred just to be on the cautious side, and so they didn't have to wind up in court again. As you may remember, on the June 22 sale, before the sale was over, we were already in court on that sale.
So, just to follow, if you defer land off of a sale, and you're saying, you're giving me the idea that they are not available for leasing, do I have to put a new expression of interest in and pay new money for it to be reconsidered in the future?
I would say just work with the state office on that one, and let's we have a conversation as to which ones they are, because it depends on if they're like a parcel that's smack dab in the middle of PHMA or core sage grouse, and there's migration corridors on top of it. Those are probably going to be we're probably not going to be able to lease those. But if it's tangential, or maybe step out acreage that may not be proximal to existing development, or maybe on the development potential, maybe the development plan may not be as apparent as we might think it might be. Those would definitely we want to talk more about with the applicant. Yes.
More of a comment than anything else. As you mentioned in your opening remarks, there's this blend in these IMs between the Inflation Reduction Act and the report. And it would have been very beneficial to the public, because one of the IMs, I appreciate that you had the reference exactly to the IRA where it's referred to, and that makes sense, we get it. It appears that, for example, IM 007 is all based upon the report. It's none of it's in the Inflation Reduction Act, and that's what I find problematic, to Steve's point, is that if the resource management plan says those lands are available for lease, it appears that it provides an arbitrary, capricious decision-making by BLM to defer a parcel that doesn't have any substance behind it. And so it's more of an observation than anything else.
Observation, we also have these IMs were issued, and we were just aware of them as soon as the public was aware of them. So,
I understand.
in the interest of time, we'll maybe take one more. And we have one more bit on carbon sequestration. So maybe one last question.
I think it was David's slide that earlier showed that Wyoming is by far the busiest, so to speak, of all the states with the BLM.
Yes.
I think this is a silly question, or it could be a silly question, but were you guys consulted in any of the new rule changes with the IRA or anything? Was the state of Wyoming field offices consulted in any changes?
Well, field offices for sure not. Probably, depending on the subject, we may have provided some thoughts on it, but we weren't, as oftentimes comes, you would get a chance to look at the IMs before they're public, so we can kind of think about them a little bit. They came out, if you look at the timeline, we were already in the middle of sales, so we're trying to have to figure out how to apply the guidance into our sales, as well as learn more about them ourselves. So one of the reasons why I've got my notes.
But we did get to comment on that lease suspension or suspension of operation and production. The field, I don't know if the field office, but the state office has at least got the chance. But the other ones, I mean, I never knew about them coming out. So just that one I know of. So just quickly, because I know we're going to talk about it this afternoon on the CO2 sequestration, but I just want to go over it quickly, just with maybe the BLM's perspective and what we're doing. I don't even know what this slide is, so we'll skip it. Okay, so just quickly, Class 2 permit if you have an EOR or disposal, and then now we have the Class 6 permit, and EPA, and then primacy state. But remember, Wyoming is one of those primacy states where the DEQ will be doing the Class 6 UIC permit approval, not EPA. And then this is a fairly important IM that came out from the Washington office on the, I guess it's the latest requirements, regulations on CO2 sequestration. Probably the important thing to look at is that pore space, we would do a pore space right away under Title V of FLTMA. So one thing that is different is the BLM will issue a right-of-way for the use of that pore space, and the pore space has been, obviously in Wyoming, been determined it's the surface owner that owns the pore space. So in those situations where you have a fee or state surface owner, the applicants, in this case, when we look at the next slide, mainly tall grass that we have in the southwest part of the state and over in the southeast part of the state, they're going out and taking leases from these landowners for the use of the pore space. The BLM is going to issue a right-of-way. So you're going to see how that's not really going to mesh together, and maybe hopefully sometime in the future, Congress will take a look at that and say, well, shoot, the BLM we should be able to lease the pore space too, but right now it's just a right-of-way process. And so you can see how that's maybe not going to match up so well when the fee and state surface owners are actually leasing their pore space with a lease. We have to make sure that any CO2 sequestration project doesn't interfere with ongoing mineral or oil and gas operations, or for any operations along those lines. And then we do a cost recovery just like we do with any right-of-way. So the company has to have money in a fund that when we do work on that CO2 sequestration project, we code to that project or to get the cost recovery. Let's see what else I wanted to. So here right now, some of the projects we have here in southwest Wyoming and over here in southeast Wyoming, those are the two major projects we have right now in Wyoming that we're reviewing. But some of the lessons learned, that pore space determination, right now we don't have any requirements in place where we can charge for the pore space. Are we going to charge for use of the pore space? Are we going to charge an injection fee? Right now, we don't have any guidance from the Washington office on how that's going to work. Hopefully in the near future, we'll get some of that guidance, but right now, we don't have that. And then the other thing, let me see the other thing I want to mention is when we do receive an application, or the ones that we have received, the first step is for the Reservoir Management Group to take a look at that application to determine if the formations where the applicant wants to sequester CO2 would fall under either a pore space determination or an oil and gas determination. And so with the Tallgrass project, with the Nugget and Madison formations, we have made that determination that qualifies as pore space, not as oil and gas minerals. And the big difference there is if it's pore space, a project can continue. If we say it's oil and gas, then that effectively shuts down the project. But more than likely, the applicant is going to choose formations where there isn't any ongoing oil and gas activities. And then after that, then we get into the right-of-way process. We would get into looking at the Class 6 injection well application that's submitted with DEQ, wait for their approval, and then kind of determine, and maybe more on the fly, is what other items should we be looking at for the right-of-way or for the actual approval of the Class 6 injection permit so they can go out there and they drill their well. So there is definitely some unanswered questions that we have going forward, but we do make that first step where we determine it's pore space or oil and gas minerals. And then I think just quickly, so some of the questions, unresolved issues, can we process simultaneous applications? I think we believe we can. We can prove a right-of-way for the same area or for parts of the same area for two different operators or two different applicants, but what will happen, it may fall under which permit is approved by DEQ first, and that may dictate about who gets to actually sequester the CO2. Is that, understand? Okay. And then, so you can be authorized. Like I mentioned before, how are we going to determine the fair market value? And what's the minimum information required to properly de-risk subsurface conflict and preserve the mineral state? We'll still have to deal with that when they actually get out there and drill their, say, test well to determine if it can actually that formation can actually sequester CO2. We'll have to work to make sure that that well will not interfere with existing oil and gas operations, because typically the existing oil and gas operations will be done by a different operator. It's not going to be the applicant that wants to sequester the CO2. So kind of on the BLM side, that kind of outlines how it works for us and then what we're looking for, but obviously we still have a lot of unanswered questions about how we go forward approving the right-of-way, the timing on approving the right-of-way, and then obviously something we don't have any control over is the timing and approval then from the DEQ on these Class 6 application wells. Any quick questions? And Bill might be able to fill in a little bit that I missed. I think he's going to.
He's going to. And so that last bit about minimum information. So it's very easy to go, is there a well drilled into the ground, and is it producing from an area that's in the influence of the plume, the CO2 plume? It's another thing entirely to be able to monitor the pressure front of the injection so that it does not affect oil and gas operations. Part of the process in the application process is to notify all the operators in the area and then have them, just so they're aware of it. The good bit of monitoring, I guess, would be coming where an operator's feeling an undue amount of pressure coming into their reservoir with a sequestration project nearby. So those kinds of things that it would be really helpful for us to have a little bit more of that basin-wide context. Maybe not necessarily the specifics for that project, but just some boundary conditions for what you're seeing in the basin in terms of pressure, porosity, permeability for a given interval. That really does help Dave and his team make the decisions they need to make, and it helps my team who monitor the production and operations, feel a lot safer out in the field. So.
Thank you both so much. Next up is our lunch break. The food is already set up out in the hallway as a buffet line. You can bring your plates back in here to eat. This would also be a great time to buy your raffle tickets or any student swag if you haven't already. We'll see you a little bit later after lunch.
Hi, everybody. Just like to say it's a pleasure and an honor to be back here speaking at the conference again. I hope this continues to be an annual event. It's a great event. It's a good time of year to do it. I've got the pleasure this year of introducing John McKinley, who will be our keynote speaker this year. John is going to continue our discussion and talks on integrity and ethics, as well as some kind of emerging things he's seen in the business. John is a native of the state of Wyoming. He currently lives in Cheyenne and is of counsel of Davis & Cannon, LLP. He is a 3-time graduate of the University of Wyoming, including a law degree and an MBA. He's also currently serving on the UW Board of Trustees, another appointment from the governor. He's a former board member of the Cowboy Joe Club. He practices mostly in natural resource law, commonly representing landowners and mineral owners in the state of Wyoming. Please give John a warm welcome, and appreciate his time in coming today. Thanks.
So I used to be able to do this without glasses and from memory, but since I'm getting old, I'm gonna use both glasses and my cheat sheet. So I don't want to correct Adam, but he mentioned I was a native from Wyoming, And I would love to be, both my parents were, but I was actually born in South America when my dad he was a geologist, and he was working in the Amazon basin for the old Belco Petroleum, which is now part of what has survived as EOG. They still have assets in western Wyoming. So that kind of goes back to, even though I didn't need to do it, it's an example of being honest and true to your integrity and your relationship with your audience. And so, to begin with, I'd like to thank Holly, SER, for continuing to sponsor this program with the student organization. And I know that they had to do a little arm twisting for Holly. But this is a great event. It's a great event for the university. It's a great event for the students here. And it's a great event for the profession. And so I hope Holly puts this reminder on her annual list so she continues to do it in the future. I'd also like to thank the student organization and Chris Koski and everything they do to move the profession forward. When I agreed to do this, there was a couple people suggested that I give a little history about myself, and I'm always reluctant to do that, but it'll help put a few things in context when I'm talking about things in the future. And it dovetails with some of the talks this morning on the profession and how your expertise and what you do in the profession, no matter what profession it is, evolves over time. So my undergrad degree was in ag business from the University of Wyoming. I then got an MBA from UW. After receiving my MBA, I went to work for Marathon in their old Casper office as a landman. That was about the time they were transitioning out of their Casper office, and I worked in their Casper office and their Cody office. I actually see one of the landmen I worked with in the Cody office in the audience. After working out of the Cody office, I went back to law school. Between my first and second years in law school, I also worked for Marathon doing land work. During that time, just the amount of exposure to the type of work that you do and the type of people you meet, it basically ran the gamut, from doing permits and easements, right-of-ways, doing stand-up title, taking leases, that whole area, that has served me well, both in my education in law school and my practice after that. After graduating law school, I left the state for a while, was in private practice with a law firm in Salt Lake City for about 5 years. Moved back to Wyoming in 1994. Went to work with Davis and Cannon out of their Cheyenne office. My practice has evolved over time from 94 till now, but it's also always had a focus on natural resources, real property types of issues. Anymore, it's almost exclusively real property related, natural resource related. And going to a question that Larry asked earlier on migration and those type of issues, that's becoming a bigger issue, and I do a substantial amount of work on conservation easements, both for landowners and stock growers, as far as putting putting together some of those projects. And I think sometimes people forget how all those pieces fit together, and the expertise that you learned during your classes here in the land management program provide an opportunity for you to really pursue a variety of areas upon graduation. You know, I've evolved from doing 100% industry work to doing almost 100% landowner, surface owner, mineral owner work now. So that's kind of my evolution in the practice. I'm going to give kind of some thoughts, and hopefully this is not too rambling. If it is, you guys, if you can get bored, get up, you can start wandering around, and I'll get the hint. But I want to give some thoughts on how things have evolved over time and maybe the future of the work, because I think the big picture is the future of land work in this profession is always expanding and developing into other areas. And I think SER and the land management program has done a really good job of capturing that, but also there's a huge opportunity for that program to expand and become more cross-disciplined across campus. You know, there was a question this morning on elective classes and what you might take. You know, when I was doing my undergrad, I had 30-some hours of electives. 18 of them I took in geology. And so you need to think about where's those areas of expertise and what areas do you want to be able to have conversations with people in your industry or profession where you're able to understand and have a very thoughtful conversation. I would emphasize that the writing skills and the analytic skills are very important, and so to the extent you can broaden your base by participating in those programs or those classes, I would encourage it. You know, when I started in the profession, that my concentration was in oil and gas, and that's kind of where I focused. That's what I did. Little peripheral involvement with some coal deals, but not on the industry side. On the landowner, the surface owner side. But all that has evolved. Wyoming's still going to be a leader in fossil fuels. They have been. They're still going to be, no matter what various folks say and the noise that you hear. That transition, whatever it's going to look like, is going to occur over a long period of time. It's not going to be a bright line in the sand. But for us to continue to be in the forefront, we have to look down the road and say, okay, what are the developing fields that we can address, both from the science side and from the real property landman side, as far as solving some of those problems. As a land professional, you'll be involved in a variety of things, but permitting and policy are areas that are developing and are important, and the more young folks that we get involved in those areas and in the profession, the better off the profession is, industry is, and the state is in shaping those policies going forward. I know that's an important area in SER, and I encourage everybody in this room to really focus on the permitting and policy, because that's kind of where things are happening right now. There's going to be a transition. We've already seen it in a lot of areas, but you have wind, you have solar, you have nuclear, you have hydrogen, all those. With that comes a gamut of various issues that arise with that particular source of energy, whether it's the production of uranium for the future nuclear, the storage of the uranium spent fuel, or the uranium waste, however you're going to call it. Huge issues. There are issues on the science side, issues on the land side, issues on the tidal side. I would encourage folks not to forget about one of our important natural resources in the state, and that's water. Your profession can address that whole gamut, and those issues are just going to be growing over time. The big policy issues on how that's going to be addressed in western United States and western Wyoming. It's just a really vibrant area of practice, and I encourage all the students to continue being on the cutting edge of those various fields, because you don't know where your real passion's going to be until you've been in the profession for a while. I'm going to mention one thing, and it's been something I've been thinking about. I was going to try to avoid hot button items, but I decided I'm not going to. It's on my list. So as a little disclaimer, these are my thoughts, not the thoughts of the University of Wyoming. And so Paula, you can make sure that these are coming from me, not university policy. But on the oil and gas side, this is a kind of an example of where this group can be the leader in shaping some of the policy. Over the last several years, there's been kind of a train wreck on the APDs at the state level for a variety of reasons. And it became a race to obtain a 2% leasehold interest so you could get APDs. Some of the companies had ideas to develop and a plan. Others, they were just banking those APDs in a fashion that they were hoping to roll them and flip them and make a quick buck. And on reflection, the first in time may have been a good policy during the old vertical wells. In this day and age, the first application with the first interest, even though they may not be that may only have a 2% leasehold interest, is that the best policy? Is that the best policy for the state? Is that the best policy for the industry? Is that the best policy for the landowner? Because it's a whole different shift from the prior process where you'd work with the geologist, you'd put a play together, the play was then marketed to somebody, and it was developed or wildcatted. It may get put on the shelf, may actually turn out to be something. Now it's become who gets that APD. I would propose that it's probably not the best policy. It's probably not healthy for the industry. Is it good for the mineral owner? Is it good for the industry? Does it promote prudent development? Is it efficient? Is it good for the small independent producer? I would question whether the current policy fits any of those well. And you as a body have an opportunity to step back and say, what are we trying to accomplish? What is the best overall policy to make sure those companies that want to develop a resource have a timely path and a well-defined path to get those APDs and actually develop the prospect. And I think that's what we want to accomplish overall, is how to do that. So that's one area I would suggest there's a huge opportunity, and maybe tweaking the current process would be beneficial for the industry, the landowner, and the state. Going to mention a couple things from this morning, just as I was sitting listening to some of the presenters. And this profession really provides the base for numerous industries and development of resources in the state of Wyoming. It started that way, it continues to be that, and it has expanded its tentacles into various aspects and various work in the state. You have on a regular basis, you have the ability to shape policy in the state, and I would encourage all the students to do that, and I encourage you to engage in that process when you have the opportunity. Some of the areas, I think the basic skills that you get when you go through the land management program are the ability to understand title work, how to do title work, what all those documents mean, problem solving, the critical thinking aspect, which is extremely important, the interpersonal ability to have conversations, convince people that the project you're working on is important and it's in their benefit to join with you in that project, and putting together the various deals, all of which you have to combine both the base knowledge and the interpersonal communication skills that make you successful in those areas. I'm going to kind of touch on some of the stuff Jacob mentioned this morning. I thought he did a really good job at dovetailing kind of the attorney ethical rules and the ethical guidelines and everything of the landman profession. I'm going to focus on kind of 2 or 3 areas, I think, and they all dovetail together. It goes back to honesty, integrity, and reputation. And if you keep those in mind, you can keep yourself out of a lot of problems, and it benefits you both with your employer, your client, and the profession at large, the people that you're dealing with on the other side. No matter what you're doing, your reputation and integrity are your most prized assets. It's with you every day. You wake up with it in the morning. You control it. And if you ever take that step that damages your reputation and integrity, it's very difficult to build that back up. And so I think it's important to just keep in mind the importance of your integrity, your reputation, your honesty. And those will serve you well. They will actually precede you in a lot of conversations or deals because people understand that and they respect it. I would urge everybody to maintain a high ethical standard and practice. You'll be rewarded multiple times over for doing that. You'll enjoy it. Your employer will appreciate it, will enjoy it. Your clients will enjoy it. There were some questions this morning on risk analysis, and I've gone through that process in several organizations, and I would propose that one of the things that everybody needs to keep in mind here is your reputational risk. And so, is what I'm going to do this afternoon going to put at risk my reputation? And if it does, you need to kind of step back and say, hold it. How do I accomplish that task and not have my reputation risk on the table? And I think it's important for students as you graduate and go into the profession to kind of keep that in mind. In closing, I'm glad, Holly, that you have seen the importance of doing this program and partnering with the students. I encourage the continued cross-discipline focus that SER has at UW. I don't know if a lot of people understand this, but SER doesn't confer any degrees, right? Undergrad. But you provide money and expertise around campus to various colleges and partner with various colleges around campus, both on the teaching aspect and on the research aspect. And so it touches, through its breadth and expertise, it touches a huge swath of campus. And so I give SER and Holly kudos for continuing to do that. Specifically this program, if you look around the country, it's recognized as one of the top performing programs. It has success in its performance, its students, and in placing students in the profession. I would encourage everybody at the break before the next program and then at the end of the program, if you haven't had an opportunity, engage with some of these students before you leave. It benefits the student, it benefits you, and they're really interesting folks to visit with. So with that, I'm going to conclude. Thank you very much. I'll take a few questions if anybody has any questions. Larry.
John, thank you for your service to the University of the State. Thanks for coming today. Could you share with us a bit of your perspective on the decade that you spent as a trustee? Why do you do it? What do you think from a personal perspective? Because everybody in this room, particularly all the young people, are going to
So, Larry, thanks for the question. And, there's a lot of people in this room that serve on nonprofits. You've served on a variety of boards. Give your time back. The University of Wyoming's always been near and dear to my heart. And over time, as I got older, it became more important to engage and help give back to the state and to the young kids. I'll probably get in trouble for saying kids, but I'm going to say young kids in the state. And the importance of providing a very solid 4-year institution in the state, the services the state provides educational opportunities for kids in the state, in the region, nationally and internationally. And that just was very important to me. And so when I had the opportunity to serve as a trustee, I jumped at it. There would probably be very few state boards or commissions I would serve on, but UW was very important to me. Hopefully, we've moved it forward. We're trying hard to expand the research and the strength of the faculty, and provide a really solid 4-year education for those students attending UW. It's not purely a focus on the land-grant mission. As you know, you can look at the Constitution, what the obligation of the state is, and the statutes. It's much broader than that, but that is a focus of this university. But without all the other moving parts, none of it can succeed together. So it's kind of my way of giving back to the state and to the kids in the state for future generations. Sorry for the long answer. Any other questions? Thanks again. Appreciate it.
Thank you, Trustee McKinley. It is so great to have UW's Board of Trustees so involved on our campus and with our students at SER. Another round of applause for Trustee McKinley. Now, does anybody need a gift to take back home to someone who did not get to come to Laramie today? Well, what about a local artist who made a whiskey decanter or a custom leather purse from a local vendor at Range Leather with a custom stamp that says University of Wyoming School of Energy Resources on it? Well, wait no longer. You're able to buy those raffle tickets right outside at the table from our students. You can also use the QR code at the very back of your program, and you can also use the QR code on your tables to buy any of their hoodies or t-shirts that they have for sale. All the profits from both of these items are going directly to the club to use for events like today, so definitely worth your dollars. During our networking break, head on over to those tables, get those raffles, because soon after this networking break, they're going to be doing the drawing, so this might be your last chance. Get those raffle tickets, and we will see you all at 1:10. I welcome you all back, and I hope you got those raffle tickets purchased, because after this next panel, they will be drawing for the winners. You must be present in order to win. But before that, we do have up Chris Koski moderating a panel on carbon capture and storage. Chris is certainly no stranger to the students in the room, as he is the director of our professional land management concentration within the academic program for energy resource management and development, and an associate lecturer for the School of Energy Resources. As if those two roles do not keep him busy enough, he is also of counsel at Long Reimer Weiniger LLP, where he focuses his legal practice primarily in the oil, gas, and natural resource areas of the law. I also have to mention that the new to SER this fall is our CCUS certificate. So if you find this panel of particular interest, see Carolina right here. today, and she can let you know how you can enroll in that program for the fall semester. Distance and working professionals are welcome in the certificate. You can complete these from a distance. And one of the fall CCUS courses is actually being taught by one of today's panelists, Professor Tara Rigetti, and Dr. McLaughlin also serves as a frequent guest speaker in some of the CCUS classes. So without any further ado, here is Chris and his panel of CCUS experts.
All right, thank you, Cammie. Before I introduce the panel, I figured I could say a couple things. First, the reason we're having this event today really is because of people like Cammie, Carolina, Holly, and most importantly, our students. The students are the ones that plan this event. They're the ones that want to see it. They're really interested in the energy industry and being able to network with you all. So, really I can't take any credit for this other than me getting to come up and ask questions. So I do want to, give a shout out to our students, and you can see, the professionalism that they've shown. I think it's been said over and over, they are trying to raise money. The money so they can travel to events. One of them is NAPE. We try to send our students to NAPE to interact with the energy industry, and so a lot of those monies to go to events like that. As Cammie said, I'm the director of the PLM program. I get the opportunity to teach these students, and I can honestly say, to me, it's not really a job at all. I enjoy it. It's fun working with the students, and one comment we always get is the professionalism that our students show, and I think that's absolutely true. So I just wanted to give that shout out. I also want to thank our prior speakers. Trustee McKinley, thank you so much for donating your time and such great information in your earlier panels. Thank you so much to everyone, and thank you all in the audience for coming out. This is an amazing turnout, really supporting the University of Wyoming School of Energy Resources and our professional land management program. I am really, really excited for this panel because I'll be honest, these are all people that I get to work with, and I think this is perhaps when it comes to CCS, one of the best panels you're going to find anywhere in the country. I would be hard-pressed that you're going to find a better, more knowledgeable group of speakers than these three. So I'm really excited. I think this will be a really good panel. I'll briefly introduce you to them with their bios. I read through their bios, and I don't think that even says the half of the knowledge that any of these speakers have. So I'll add that caveat. But so the way we're going to do this panel today is we're going to kind of give a technical side and then a legal side, a legal regulatory side. So I'll start with over here with Dr. Fred McLaughlin. He is the director of our Center for Economic Geology Research, or called CAGR. And reading from his bio, Dr. Fred McLaughlin has spent the majority of his career evaluating the geologic and economic resources of the Rocky Mountain region. In his earlier career, McLaughlin focused on field evaluation and developmental geology, primarily associated with energy and economic geology. For the better part of the last 10 years, his career and research focus has been developing commercial-scale CCUS projects, mainly in Wyoming. McLaughlin has been a part of, led commercially focused carbon storage project and helping to design, permit, drill, and complete the state's first CO2 injection wells. For those that don't know, that's near the Dry Fork Station by Gillette. He was a founding member of the University of Wyoming's Carbon Management Institute, co-leading UW's largest commercially focused carbon storage project and helping to design. Dr. McLaughlin earned his BS, MS, and PhD from the University of Wyoming in geology and geochemistry. Outside of his bio, his office is right next to mine, and it's pretty amazing. I'll just say, hey Fred, what do you know about I don't know, Niobrara County? And he'll say, well, what depth? And he'll just spout off the formation. So literally when it comes to rocks in Wyoming, I've talked to several people, and I don't know anyone that knows rocks better than Fred. So I'll give that shout out, and I appreciate his willingness to always talk to me on those subjects. Next up, we have Professor Tara Rigetti. I think probably everyone in this room knows Professor Rigetti. She is the Occidental Chair in Energy and Environmental Policies and Professor of Law. She teaches in both the School of Energy Resources and the University of Wyoming College of Law. Her research focuses on governance, property, and administrative law issues related to energy development and carbon removal, including on split estates and federal lands. Regularly sought for her expertise and aid on major energy and carbon storage projects nationwide, Professor Righetti is a renowned expert on U.S. energy law, and her knowledge and contributions to the field of CCUS policy is unparalleled. Professor Righetti has published peer-reviewed articles in leading law journals, both nationally and internationally, where her scholarship is regularly cited. Professor Righetti was awarded the Fulbright Scholar. She studied in France, and she is currently the co-director of the Nuclear Energy Research Center at the School of Energy Resources. I'll add a couple things. Professor Righetti, 5 or 6 years ago, or whenever that was, says, "Hey, Chris, you want to help me on my pore space research?" And I thought she was off her rocker at the time. I didn't quite see that pore space would be such an important topic. She's been a leading scholar in this area for many years, and really has seen the potential in this area when people like me thought this was, pie in the sky, and I was clearly wrong. Next up, we have Andrew Emmerich. Andrew is currently a partner with the law firm of Holland & Hart. He's based out of Denver, Colorado. Andrew has practiced energy, environmental, and public lands law for over 25 years, first as legislative counsel to Senator Mike Enzi in Washington, D.C., and then as counsel to the Assistant Attorney General from the Environment and Natural Resources at the U.S. Department of Justice. He has represented a variety of federal agencies, including the BLM, EPA, and the Forest Service. He has advised and advocated for private clients in the areas of regulatory compliance, contracting, permitting, and litigation since he joined Holland & Hart in 2005. I've had the opportunity to work with Andrew over the last couple years. Fantastic, brilliant attorney, and you're probably not going to find many people out there with his knowledge and insight into some of these regulatory issues in CCS. So, like I said, I'm really, really excited for this panel, and hopefully you all will be as well. To start off, I figured we would kind of go first and look at, well, what is carbon sequestration? What are some of those technical hurdles that we really have to worry about in developing a carbon sequestration project? And then kind of move into talking with Professor Righetti and Andrew when it comes to, okay, here are the technical hurdles. What does that look from a regulatory, legal, and land standpoint? What are some of those issues that have arisen? We've heard of some of the BLM guidance from earlier today, talking what does that mean for pore space development here in Wyoming in the West. So with that said, I think I'm just going to hand it off to Fred to spout off some of his very in-depth knowledge, and just first ask the question, if you can kind of give us a brief technical overview of what is carbon sequestration, what's the technical process for carbon sequestration?
Well, sure. Thanks, Chris. And luckily for the people in the room, this should be shorter than Chris believes, if I get to spout off my knowledge. So going back to the broad question, what is sequestration? It is taking typically a point source CO2 resource, mainly from an anthropogenic plant of some sort, be it power or industrial, building some sort of facility to capture said CO2 and then storing it underground. So it has a lot of similarities between oil and gas with what you might see on the surface with respect to transportation, compression station, wellheads, etc. for the land people in the room, but a completely different regulatory environment.
All right, and so that's what generally we're doing, and presumably there's some geologic characteristics that we're going to look for to where we're going to actually store the CO2. And can you kind of give us an overview of what are the geologic characteristics that one might look to when they're kind of identifying potential targets for storage, and here in Wyoming as well?
Yeah, absolutely. So what we're looking for are pore space resources. Those voids in the rock where we can actually store CO2. So that's first and foremost. And they're not as prevalent as people think. Kind of general rule of thumb, as a basin builds, and typically we're in a basin somewhere for storage, 80 to 85% of the rocks are going to be impermeable. It's just the way a basin builds. We're very lucky to get some high porosity permeability rocks in parts of Wyoming where we can do CO2 storage. That's one thing. Then you need the ability to keep those pores contained. So you need a large volume, preferably, of impermeable rock over top. Now, Wyoming has a lot of those. We're very lucky. We had several instances where there were ancient seaways that laid down sometimes up to 8,000 feet of ceiling type rocks over our formations. We've done studies in Wyoming. Some of the oil and gas that we produce out of the Bighorn Basin was generated well over 100 million years ago. Wyoming holds helium and hydrogen underground for geologic time periods, so we do have rocks that are very good at doing this. We also look for places where the water is saline. I'm sure you're well aware, if you know Terra, that you need to inject into a reservoir that is at least 10,000 parts per million. Not always easy said as done, but luckily we do have some of those in Wyoming. And then we want to look for places that don't have mineral resources. Again, you guys can opine on that better than I can, but we can't impede on somebody's mineral rights, so we're looking for saline reservoirs. And that's very interesting from my point of view because that's flyover country for oil and gas. So the massive wealth of subsurface data we have to divine geology in Wyoming often bypasses the reservoirs we're really interested in CCUS. So we've got to kind of do some virgin studies on some area that haven't been explored or published before. Last but not least, we look for low-risk geologic scenarios, no faults, no fractures, no other things that might allow the CCUS or the stored CO2 or brine that you're displacing to move.
Well, great. So it sounds like in general terms, we're looking for sedimentary rocks, right?
Well, largely in Wyoming sedimentary, but other places we actually look at mafic rocks like basalt. So Wyoming was just awarded a new study actually in Oregon, outside of the state boundaries, but we get to do some fun science every once in a while, to look at mineralization in a basalt flow in Oregon. And the neat thing about CO2, in this case at least, it's slightly acidic mixed with water. Mafic rocks, which are like volcanic rocks you see in Hawaii, are basic by design. So you put those two together and you actually mineralize CO2. Sometimes in sedimentary rocks, you're putting CO2 down at depth. You want to be deep, like below 3,000 feet, because then it's more like a liquid than a gas. You get a volume increase, so you optimize your pore space. But it can stay gas for a long, long time. In mafic rocks, it can actually mineralize and turn back to rock, which is a safer containment unit for the long term.
Well, great. So Wyoming specific, I know that you've done a lot of research here, and where in Wyoming would a developer kind of look to site one of these projects? Are we in certain basins? Do all the basins have potential? Where exactly do you see kind of development that might take shape here in this state?
Thanks, Chris. Great question. So actually, all of our basins have potential, but there's 3 basins that have eyeballs on them right now, and that's the Greater Green River Basin, the Denver-Julesburg Basin, and the Powder River Basin. That's largely due to source. So there are CO2 sources in those basins. You guys are Landman trained. You can understand that you increase your project risk if you have to mobilize CO2 with pipelines or other things. So ideally, the first projects in Wyoming are looking at geologic storage right adjacent to the source itself. So there hasn't been as much work done in the Bighorn or the Wind River Basin, but there's not very big CO2 sources there.
Well, great. Appreciate that. So presumably, if we solve some of these pipeline and source problems, or we can get the CO2 to the Bighorn and Wind River basins, those might be potential targets as well.
Absolutely, presumably, yeah. So one of the interesting things that we're actually trying to study now and understand is actually the availability of pore space resources. So I mentioned earlier there's a lack of reservoir-type rocks overall per volume in a basin, and then we're lucky, say we have a 100-foot reservoir, we might be lucky to only utilize 10% of the pore space. So there's laws of diminished returns. It's just how fluid injection works. So what we're doing now is doing our best to provide all these storage management options for all of Wyoming, because we do think they're probably needed in the future to meet some of these companies' goals for sequestration.
Great. And I'd mentioned to the audience earlier about the test well that School of Energy Resources has done over by the Dry Fork Station. Fred McLaughlin's kind of been really in charge of that project. My understanding is we've drilled 2 test wells now. Are you able to share any information about that project, or is there any information that we've learned throughout that project that might actually, that can help development? Just kind of an overview of the project.
Oh, I don't think we have enough time there to have an academic share what they learned drilling deep wells. It was a lot. Actually, one thing we learned was there's a generational gap in drilling these kind of wells. So for the last X years, everybody's drilled horizontal wells, very comfortable doing this. To find people, again, with the expertise to drill these deep horizontal wells was really challenging. And they're deep horizontal by nature science wells. So an oil and gas well, once they figured out how they do this, they kind of cookie cutter an oil field or basin, boom, 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 boom. They don't much change anything once they get their permits in place and operations that work. These are science wells, so they're all going to be different. They're held open for a long amount of time, which increases your wellbore risk. You have to get certain data out of the well to complete your permitting, which is very challenging sometimes. Not all wells work the way they should be. And again, a lot of these are a lot deeper than we've drilled in a long time. So even having the right tools and service companies available to provide you the resources you need to get that Class 6, those major headaches. Geology's beautiful in Wyoming. That was lovely, great core back. Well logs, we'd love to share it with all of you. That was neat, but those operational challenges are going to be really hard for the industry.
So it sounds kind of like what's old's become new again. You know, when we were drilling these deep vertical wells years ago, and now it's kind of coming back.
Absolutely right. One of my first geology teachers, I always remember, said, if you get into something and it kind of dies out, just wait 25 years, it'll come back. So.
Well, great. And I have some more kind of technical questions, but I think they're going to kind of fall into some of these legal questions. So we'll keep Fred here. The next questions I'm kind of going to leave open to Professor Rigetti and Andrew Embrick here, and kind of leave it to their discretion on who wants to tackle the question. But I think a big reason a lot of you are here is to understand how do you permit a Class 6 well? What does that look like? So my question for our legal panelists over here are, can you give us an overview of the regulatory process for carbon sequestration in Wyoming? How does that maybe differ, or do we know how that looks in other states? And generally, what do land professionals, a lot of our landmen here and lawyers today, need to know about those processes?
Okay, well, thank you first all for being here and for the opportunity to talk on this topic. I think one of the reasons that I'm so excited about CCUS is that there are so many parallels to the things that landmen do, and you're doing it on a tremendous scale. So working with a variety of state and federal agencies is one piece of that. Getting rights of way, getting pore space injection rights, and then permitting the well, which is what Chris mentioned, and that happens under Class 6 of the UIC program, which is part of the Safe Drinking Water Act. And Wyoming is one of, I think, 3 states now that has primacy over that program. So there's North Dakota, they were the first, Wyoming was the second, and just this week it was announced that Louisiana received their primacy, so they're the third. And if you actually look at where sort of the project funds are going right now, they're going to those 3 states. And part of that is because I think of the investment those states have made in developing out their legal structures and regulatory systems to provide more certainty to project developers. There's not perfect certainty, and I think there's still work to be done in this space. And sometimes people say, well, what about this, what about that? And it's true, right? There's issues that, because these are first of their kind projects, we're still solving, but it's 10 times harder if you go anywhere else where you don't have the type of legislation that's been put in place here starting in around 2008. So Wyoming defines ownership of pore space statutorily as being held with the surface owner unless it's been previously or specifically conveyed. That adds a lot of certainty. There's specific structures for liability transfer, for amalgamation or unitization of subsurface interests. A lot of those pieces that are really core, taking the expertise and knowledge about how to manage common pool resources in the oil and gas context, and then applying it to CCUS. Of course, there's a lot of things that are different because you're putting something in rather than taking it out, but a lot of it's the same too. Just talking about kind of the scale of some of these things, if you have put together a 1280 before and you think about all the work that goes into that, that is like a postage stamp compared to the size of some of these projects. And so I think that's something that's really exciting about it. There was a report by Net Zero America that estimates that you would have to have 110,000 kilometers of new CO2 pipelines built in the next 20 years to meet the goals and to scale up carbon storage to the scale that is expected for carbon removal to meet climate goals. That's more pipeline than has been built across all categories of pipelines in basically the last 10 years. So the scale of infrastructure, project development is tremendous, and I think there's a huge opportunity there as well. Do you want to talk more about Class 6? No. Okay. Okay. I'll let Chris jump in then.
Yeah, well, Professor Rigetti did mention something that I didn't realize at the time too, but I do now that we're kind of getting into some of these projects. We're used to dealing with 2 sections of land for a project. As Professor Rigetti says, these CCS projects are substantially bigger. So more land work, good for us in Wyoming, good for our students, great for the industry. So leading into my next question, I figured since we have some students here that have assignments due next week, some that are in advanced energy law, they were given the assignment to, craft a pore space lease, a joint operating agreement, an assignment for an operator that's looking for partners in a CO2 development project. The reason I gave them this project is because they couldn't go online or use ChatGPT to find this particular answer. So they actually had to come up with this all on their own, and some of the results are trickling in. I'm quite impressed. So leading to this question, and this goes both to Professor Rigetti and Andrew Emmerich, we're kind of on the verge of drafting some of these first agreements in CCS. What does a land professional need to keep in mind when they're drafting these initial leases? What types of provisions should they really consider to be part of your pore space lease that might be different than your traditional oil and gas or wind lease, or how would those agreements relate? And for those students that have assignments due next week, you certainly should tune in.
Okay, I'll take this one too. I think partially when you look at oil and gas leases, there's this temptation to sort of just change a few terms and use an oil and gas lease as a carbon storage lease. And I think there's some things that are really important to consider. First, you're talking about putting something in the ground and leaving it there forever. So that, we all hope it's forever, right? So that's the first challenge, is a lease terminates at the end of the habendum clause when you have cessation of production in paying quantities. But if you're going to store something forever, you need to also have a perpetual right to that container. How are you going to frame that, for example, so that even at the conclusion of injection operations and continuing on for that period of monitoring, reporting, and verification up to site closure, which could be 30 or 50 years, and then continuing on beyond that in perpetuity, you have a right to store the CO2 there, and you also have restrictive covenants to prevent other people from breaching that storage complex in a way that could result in a release of CO2 to the surface. So that's probably your first challenge. The second challenge is looking at how you're going to valorize the pore space rights. And while the Texas lease that was issued with the sort of Texas State Land Board uses a royalty structure, a royalty structure is really difficult if you're just looking at a percent, because it's a percent of what, right? We can measure the volume that is being put into the ground, but exactly what is the value of that when you're looking at all of the infrastructure and other things that come into place, applying like a work back method like you would do for an oil and gas royalty really doesn't get you there. So that's another thing, is thinking about how you're going to structure your compensation provisions. And then I think dealing with things like drill through rights, particularly if you're dealing with somebody who has mineral rights, right? What would it look like to develop mineral resources that underlie your storage complex in the future. Maybe those have already been identified, maybe not. Like Fred said, while depleted oil and gas reservoirs are really good potential targets for storing carbon, for the most part, people aren't looking at putting CO2 in and producing unless they're doing so in the context of EOR right now. So for saline storage projects, and that's mostly what I'm referring to here, you think about how do you keep that container really, really sort of watertight or gas tight in this case, while also continuing to allow full utilization of other layers in the subsurface to their highest and best use for both surface and minerals.
Great. So my next question, and I think Professor Righetti gave a really good overview of just these considerations that aren't really necessarily on our mind when we're looking at these projects. One thing I think we realize in Wyoming is, it's no secret that we have a lot of federal lands in Wyoming, and we learned about these projects being a little bit bigger than a typical 1280. So first I want to say thank you so much to Dave Chase and Bill Beck from the BLM coming out and talking about some of the new IMs, the guidance from the BLM, and really to you in the audience probably providing some of the first time that people have heard of how is BLM looking at this. And so given the strong federal lands tied here in Wyoming, my next question is that CCS projects in Wyoming have a real high chance to include federal lands, especially when we're talking southwest Wyoming, which is majority federal lands. And so this is to both Professor Righetti and Andrew, but can you give us a brief overview of the current understanding of the process for obtaining rights for carbon sequestration underneath federal lands here in Wyoming? And are there any additional considerations to be considered? So I'll hand that one off.
Thank you, Chris, and it's really an honor to be a part of a panel like this. After all the academic accolades of everybody to my left, I really should preface my remarks by, I'm not an academic, I'm a practicing lawyer, and this presentation, or my part of it, can be sort of labeled the musings of a country lawyer. First of all, two observations, the prerogative of the holder of the mic here. First of all, the School of Energy Resources is really just top-notch. I've never spoken at this conference before. I've had the great honor of speaking at the landscape discussion of energy law and policy that they have in the fall. And what I will say is that Holly and Chris and Tara and the entire team have really set the standard for what I think is academic excellence as well as practical application. And the interdisciplinary approach they take of having lawyers come together to talk with policymakers, to talk with professionals in the industry, is really second to none. And having attended a lot of conferences throughout the region and nationally, this is one of the very best. And for those of you who are students, it's a great honor to study under people of this caliber. Second observation is this: I've never spoken at a Landman conference before, but one thing I noticed from the outset, we started the conference this morning with an ethics presentation, which, by the way, Jacob, was really first rate. That was terrific. Having spoken at a number of legal conferences, typically at a legal conference, they'll sort of wedge ethics in at the end of the day, after the substantive presentations, and right before the start of happy hour. So that probably tells you something about the difference between the two professions. Circling back with the question about federal use, so we did have I think a very good discussion this morning that Dave gave an overview of sort of the federal lands piece of this. I think as you probably gleaned from his remarks, neither BLM nor the Forest Service has specific regulations that govern CCUS. They're relying on a general authority under FLTMA, which I think everybody probably knows is sort of the overarching statute that really gives BLM a lot of its broad regulatory authority to manage federal lands outside the mineral context. Those are generally governed by the Mineral Leasing Act. So BLM has issued the IM last summer where they basically decided that they will issue right-of-ways under Title V of FLTMA. Now, interestingly, Title V applies not only to the BLM, but also to the Forest Service. So as a statutory matter, whatever authority the BLM has under Title V, so too does the Forest Service. The BLM has issued an IM in which they've basically said that they will, it sort of supplements their regulations at 43 CFR Part 2800, which are the general right-of-way regulations for the BLM. And I think they did set forth a lot of the key terms that, like, how long is the right-of-way going to be? It's going to be a minimum of 30 years. What sorts of due diligence does BLM have to do on the front end? Well, they have to determine who owns the pore space. That's an easier question in Wyoming than it is in some of the other western states. They have to determine whether there's going to be a potential conflict between mineral resources. They require the right-of-way to have stipulations so that there isn't going to be an improper interference with the recovery of the mineral estate. So we sort of see a lot of the markers that were put out in that IM that sort of gives a bit of a blueprint to BLM. Now, the Forest Service, as you may know, has not issued any sort of comparable guidance. So the Forest Service, as we sit here today, would authorize right-of-ways under Title V through the agency's special use regulations. And those are at 36 CFR 251-50, and essentially all these kinds of uses on Forest Service lands are considered special uses. So what they do is they take the general authorities like Title V of FLTMA, as well as other organic authorities that under the Department of Agriculture, and they sort of run it through a screening process to determine whether or not CCUS storage fits within the kinds of uses that are otherwise acceptable on Forest Service lands. Now, they do not have administrative guidance yet, but the Forest Service did issue a regulatory information notice the beginning of this year in January, in which they told the public that they are considering rulemaking in which they would consider whether or not they could authorize exclusive and perpetual use of CCUS storage on Forest Service lands. The date that they put in their notice for the notice of proposed rulemaking is August of this year. So we may see something from the Forest Service as early as this summer on sort of what their trajectory will be if they're going to actually undertake a formal rulemaking. Now, what are some of the open questions? I think you sort of get the general contours, but a lot of the questions that come up are sort of the timing. How is the choreography going to work, for example, if you're looking at a project that involves private lands, maybe state lands, and federal lands? Private lease agreements, I think, has already been indicated very well by Tara. Those are exclusive pore space rights. The state land lease also gives exclusive pore space rights to specific formations. So this is one of the questions, I think, facing the BLM and the Forest Service is, are they going to grant exclusive rights? And if they are not, what is the right that a right-of-way grantee would hold? Another question is, what would the document be? When you're given a right-of-way grant, what is that? Now, FLTMA defines right-of-way as, it can be a lease, it can be a permit, it can be a license. So it could basically be, or an easement, by the way. So any of those sort of legal vehicles could be issued when they give the right-of-way grant. So one of the things that BLM will have to work at is when they give a grant, which one of those property documents will it be, because that will also, in large measure, determine what kind of rights are being conveyed to the grantee. And then I think one of the other things is the choreography between the federal land management agencies and the Department of Environmental Quality. As Tara pointed out, permitting in Wyoming for Class 6 wells is done through Wyoming DEQ. And so the question is, what do you have to take to Wyoming DEQ in order to get a Class 6 permit? Under Wyoming statute, the applicant has to demonstrate that the applicant has the legal control over the geologic sequestration site. And that's basically defined as the pore space where the CO2 is actually going to go. So if you have to demonstrate that you have the legal control, the right to inject that, what does that mean? Is it going to be an exclusive lease? Is it going to be something less than that? What will DEQ look to in order to give the Class 6 permit? And then ultimately, as we understand the way BLM is currently looking at this, after you get the Class 6 permit, you would then go back to the BLM and get a notice to proceed to injection activities. So hopefully that helps fill in maybe some of the detail.
Well, that's great. I think there was a real important point that we, that are used to oil and gas, we're saying, oh, I got to do something subsurface. I got to go deal with the Bureau of Land Management. That's from the Mineral Leasing Act, which gives BLM authority over both BLM and Forest Service lands. Here in this new arena, if you're going to do a project that's going to include Forest Service, you're going to actually have to work with the Forest Service for the subsurface right, at least how the statutes and rules are currently crafted. So a very important point that I think Andrew Emmerich raised. He also raised the point about this idea to go, you need to show effective control to get a Class 6 permit at the DEQ. My question, I'm going to go back to Fred. Sorry to put you on the spot. Is, when we talk about effective control and exclusivity, from a technical perspective, are there any concerns if we had multiple injectors into the same formation in the same area? Is that problematic from a technical standpoint?
Oh, absolutely. Yeah. Yeah, that would be bad business practice. So again, you have a finite resource, and it is the pore space. That's it. And each operation has to model their impact of the injected volumes. Well, you couldn't even do that properly if somebody else was right in your same formation doing the same thing. Now, you can sparse out. I mean, there's a lot of Wyoming geology you could spread, but I guess we're being hypothetical, right? Like, if part of your business plan was to divert a lot of money to lawyers, then yeah, that'd be a great business practice, and you would be able to do that effectively. But not if you're going to actually build a pore space or a CCUS project that took best advantage of the pore space, no.
Well, great, and I think that's an important point that Andrew and Fred has made is, this is kind of a little bit different, because as I understand from a lot of discussions with Fred, is that when we talk about Class 6 wells, we actually have to model what our pressures are, and that's really important, and we got to be able to forecast kind of accurately what our pressures are, and so I'm kind of not necessarily on my list of questions, but it's related. So I'm leaving it up to the panel and saying, it seems that if we have multiple injectors in the same area, we're gonna struggle to actually be able to even model and get our Class 6 permit. Or is that the kind of the current understanding?
Well, I'm not going to talk about modeling because that gets out of my sandbox, but I think there's something that's really different about the Class 6 program and about how it sort of interplays with some of these state laws as well for liability transfer, is that there's this idea of this being sort of a defined area, and all these, in addition to the modeling, right, you have these monitoring, reporting, and verification requirements that continue for decades after these projects are done. And one of the goals of those programs is to demonstrate plume stability, to demonstrate that there's not migration, that there's not any seismicity activities, and demonstrating that over a period of time is kind of the trigger for being able to get your site closure and eventually transfer control of that CO2 to the state under the state kind of framework. It's really hard to imagine from a legal perspective how you would demonstrate that in addition to the technical risks that it might pose if you have multiple activities happening in the subsurface in the same formation, right? Because the CO2 plume in the area, it's like in the same way that Fred mentioned, it's a depletable resource, it's rivalrous, it's going to be subject to those same factors of pressure and other things that oil and gas is. And so action over here is going to have an impact over there. And so being able to draw a boundary around your project becomes really important, but you can't fence it in the way that you could with a surface resource. And so I think that creates problems in terms of how we apply the legal frameworks under Class 6 and under state law, in addition to any problems that would come from modeling. And then I think there's a host of commercial problems that exist as well. If you're forecasting being able to inject a certain volume to make your project work financially and from an economic perspective, and then that volume is effectively subject to capture through multiple injection activities, you lose the benefit of optimization, and it may actually add enough uncertainty that some of these projects don't go forward. Do you guys want to add to that?
It's beautiful. Yeah. Well, kind of a related question, and our students are working on this project, and they say, what do I need to look at? And I keep saying, well, look at Chapter 24 of Water Quality DEQ Rules, because that kind of lays out the process for filing your Class 6 application. When I look at those rules, I see references, and we've kind of talked about this a little bit, to area of review. So I'm kind of leave it open to Professor Rigetti and Andrew. We hear this term area of review. What is kind of this area of review? What does a developer need to know? And what should land professionals keep in mind when they're leasing or permitting a project? So it's kind of a vague question, but I'll leave this question of area of review. Hopefully you can opine on that.
The first shot at that one. So the area of review under the Class 6 program is basically the broader area for the entire geologic sequestration project. The way it's defined under the DEQ regulations is it includes the three-dimensional extent of the CO2 plume, so that's the actual CO2 you inject underground, the associated pressure front, so when you put the CO2 underground, depending on the pressure differential, you can actually have a front that goes out some distance in front of the CO2, and it also defines it as any displaced fluids, and then also the formations above the injection zone and the surface area above that. So essentially it could be potentially a much broader area. Now I mentioned earlier the defined terms under Wyoming law that are important to keep in mind. One is geologic sequestration site. So under Wyoming statute, that's only where the CO2 is located in the pore space. The area of review is basically includes the entire geologic sequestration project, and that's the terminology that the EPA regulations. So that could be, depending on the particular formation, that could be much larger than where the actual CO2 is. Now, why is that important? Under the regulations, both the DEQ Chapter 24 and EPA's regulations, an applicant for a Class 6 permit has to basically delineate the area of review. And the reason is the agencies, whether it's DEQ or EPA, they want to know if there's any risk of this sort of pressure front, which again could be some distance out in front of the CO2 plume, is going to cause the migration of fluids into any sort of well or conduit. So it's basically designed to protect drinking water sources. That's the point of it. And so what you have to do when you file your application is you have to model how far out you think the pressure front will extend beyond the CO2 plume. Then you have to identify whether there are any conduits within that larger area. And if there are, you have to put together what they call a site, as part of your site characterization, you have to basically have a corrective action plan. So you have to go to DEQ and say, all right, if there are wells that are potential conduits for CO2 or displaced fluids that could be some distance out from the actual pore space that I lease, you have to be able to show the agency that you can remediate those. Now, this is actually fairly important for a couple reasons. One is it really depends on the specific formation whether the area of review is larger or coterminous with the actual CO2 plume. So the EPA has put out hundreds of pages of sort of administrative guidance on this question, and they have different sort of models that you can look at. In some of those, the area of review is basically the same size as the CO2 plume. In most cases, it extends beyond that. And so there are various sort of technical ways of defining exactly how far out that goes. But what's important as a regulatory matter is, for an applicant, you do not have to show that you own or control the pore space in the entire area of review. That's not required under the regulations. You have to own or control the pore space where you're actually going to put the CO2. But the larger area where the pressure differential may extend, the only thing you have to show is that you have site access for any sort of corrective action. Now, what's important about that as well is that both the EPA regulations and the DEQ regulations allow for phased corrective action. So if you have a large geologic sequestration project, it may be years before the pressure front ever gets to a potential conduit that is out in your area of review. So what you have to be able to demonstrate is that you're working on getting site access. You don't actually have to show that you have present site access to all of those further conduits at the time you file your application. So I think the things to keep in mind are, what is it that you actually have to control? The pore space where the CO2 goes. The broader area of the area of review is your corrective action, your site characterization, and you would have to show site access to sort of remediate any potential conduit.
One thing I wanted to add to that is I think that's so important as well as a policy matter, because in the same way that you could have waste in oil and gas, if you actually had to tie up all of those rights in that pressure area, effectively for non-use, because you'd be saying we're just going to hold them to allow the pressure to be there. I think that that would ultimately kind of create a phenomena, and we've seen this in the context of wind, of moating, where people would be creating huge areas that would be kind of dead zones from a property rights perspective, because you would have to lease those, but then you wouldn't be able to have any injection activity in them. Ultimately, that's going to result in waste of the subsurface storage capacity and inefficient use. For the landowners who actually have CO2 going into their land, their economic benefits would be tremendously diluted, or you're going to have people who then get no payments because there's no CO2 going into their land, but yet their land would be tied up and unavailable for other, other uses. And so I think the legal framework that Andrew describes makes sense from a policy perspective and trying to optimize efficient use of the resource, for numerous purposes and goods.
Well, great. That was a fantastic overview, I think, of area review, and even I learned some more things. So thank you. Kind of shifting the question, and a question a lot of you are going to have. People have come to me and said, "Hey, Chris, someone wants to lease my pore space. How much should I ask for? What's the fair rate?" And that is not an easy question, at least for me. And it's not just landowners. Developers want to know, if I want to do a project, what do I need to offer? To even understand whether their potential project's going to be economic. So my question is, do you have any insight on, what might a fair rate be, for pore space? How do we determine it? And what are some ways that agreements might be structured, to ensure, a fair rate for pore space owners, but at the same time to make sure that projects are economic and can actually go forward. So I'll leave this open. I know Professor Righetti has done some research here, and curious if there's any thoughts.
So there's a number of publicly available agreements that you could look at from all over the country, mostly dealing with state land agencies. That includes Wyoming. You have one example in Wyoming. There's 4 or 5 in Louisiana, 1 in Texas, some in Illinois and Indiana. So you could look to those, and if you were to put them all on a chart, it would be a complete scatter. The values that are being paid are all over the place. I actually don't think this should be surprising to anyone, because first, and Fred could go into this, the pore space itself, like he kind of said, is so particular, right? It's not all created equally, where it can just be interchangeable, and it can vary, even within relatively small areas. I don't know, I think you described once that there were like pockets that were like potato chips, and if you're in the pocket, you have pore space, and if you're out, you don't, right? So, but there's all these other factors too, about what is your distance to infrastructure. If you think about pore space as being like a warehouse that's on I-80 is going to be way more valuable than a warehouse that's not, because how are you actually going to get goods to and from that place? So that's going to be really important. Another question is, how close are you to point sources and availability of CO2? Because it has to come from somewhere. And so that sort of ability to then get and transport of CO2 is tremendously expensive as well. So if you have to transport the CO2 1,000 miles to get it there, that affects project economics. And even if your pore space is really good, because it has to have that transport cost, right? The effective sort of utilization of it is going to be less valuable than pore space that's located right next to the pore space, the point source, and doesn't require any transport. So it's really hard to like pin a number on it, because in doing so you would like almost certainly be wrong. And I think we're seeing this market develop, and as it's developing, you will start to see sort of regional norms emerging. But my main takeaway would be that it depends, and it's not sort of uniform. If you look at an agreement in Louisiana, those terms maybe just don't work in Wyoming. You want to add to that, Fred? Andrew? Okay.
Well, great. So my students will probably admit that I don't necessarily always do a great job finishing on time, but I'm going to try. So I'm going to skip around questions a little bit and leave this kind of very open-ended question. But I know all of you are involved in some of the literally first commercial projects in the entire country for carbon sequestration, which I think is just amazing to have this panel. But, as these first, kind of projects are underway, what are some of the challenges any of you are seeing that developers need to be aware of here in Wyoming, but maybe even more broadly? So I know that's a very broad question, and I'll give each of the panelists an opportunity to give their thoughts on that.
All right, so we've been thinking about this obviously from the technical side. So one of the challenges is how people get paid. The 45Q starts on day one of first molecule in the ground. So you want to have your field developed and ready to go for whatever your maximum injection rate is on day 0, which you would never do in oil field and gas. All right, you would drill a couple exploratory wells, you'd pump and pull for a while, and then you'd infill. So I'm really worried there because the challenge with getting paid that way is you have to be ready to go, but you'll never be able to use your resources to the optimal advantage in that point in time. The other thing we're seeing is a delay kind of in the service industries. So I'm getting off subsurface here because we're moving into commercial. There's not the right kind of steel manufacturers in the United States now. The last big amine capture facility, and let me step back a second, all carbon commercial technology for capture, for sequestration is proven. It's completely 100% commercial. It's just boutique still. So the last big amine capture facility to develop for the United States was built in South Korea, shipped over on a super tanker, and then trucked into Petronova. So the costs still are really exorbitant. So the first movers in this space are kind of the high risk takers. So kudos to them, and I know there's some in the room because I think everybody's going to benefit. But in terms of continuing to roll these things out, pore space optimization, making sure we're doing good infill builds, and trying to develop reasonable and effective monitoring systems that can give us the data we need. Those are things we're really wrestling with right now for that next stage of commercial research.
I'm going to sort of say, Fred, I think the biggest issues for CCUS are legal and regulatory and policy more than technical. I think we need the geologic characterization you've talked about, but when you look at bringing this to commercial scale, probably the biggest hurdle I see is how do you coordinate across jurisdictions and across different types of land types. So if you have a project that includes private land, state land, federal land that could be managed by multiple different land management agencies, and then one that maybe crosses jurisdictional boundaries between not only counties but across state lines. As you all know, we have this beautiful legal fiction in oil and gas that all oil fields end at the state line because you don't have this idea that you have to have a two-state unitization. Well, with these CO2 plumes, it's very likely they will go across state lines, and so you could have a place where you have primacy in one state and yet not in the other. So EPA is administering the program in one state, a state agency is administering it in another. How do these different agencies work together and different sort of landholders work together to bring in all these pieces? Because it really only works if you can create that big area of exclusive control with a uniform regulatory framework into which you can inject CO2 over a period of decades and then hold the CO2 there over a period of centuries. So I think that's a huge challenge. It's a challenge for regulators and it's a challenge for landmen and lawyers as well.
I would agree with all those points. I think for a developer, the amount of capital investment that needs to go in on the front end of these projects is considerable. And for a company and their shareholders or their board to sort of dedicate that kind of investment, there has to be a sufficiently clear sort of regulatory trajectory and timeline to bring one of these things online. So the greater certainty that we get in terms of the coordination between the regulatory agencies, so the land management agencies, the state, in case of Wyoming, state DEQ or another state's EPA, that would be a big plus. Once we actually get a clear trajectory for land management agencies about what needs to happen from the applicant or the developer at what stage, I think that will provide greater clarity to know what do you really get with a right-of-way, for example, on federal lands. Will that justify the kind of capital investment that's required to go to the next step and sort of prove up the resource, to drill extraordinarily expensive site characterization wells? The infrastructure investment, all of those things I think will follow once we get greater regulatory certainty. The cross-boundary issue, I absolutely agree with Tara, is a big one, because I think as we start to look at some of the larger projects and where some of the formations are, it seems to me likely that this issue of the plume, or certainly the area review, so that's, again, the pressure front, extending into states outside of the state that's actually issuing the Class 6 permit seems to me more likely than not. And so that issue, I think, has to be worked through. So I think you see all sorts of challenges. The exciting thing is that as long as I think there's goodwill by the regulators and a real willingness to kind of partner with private industry, I think this is something that can happen.
Well, great. I guess because I never actually looked this up, even when they give me the school schedule, does anyone tell me what time we're supposed to be done?
2:20.
Oh, okay. We got plenty of time for more questions.
Good job. We want questions.
All right. So I have a whole list of potential questions. Well, if you guys want to, before we get there, I first, so because we're a land grant institution, which means that this school is funded by a lot of what we call our school lands. So I kind of have a question, probably for Andrew, but maybe both Andrew and Tara. You know, we have a lot of state lands in the state of Wyoming. You know, I assume that some of those lands are going to become part of projects. What would that process look like if someone wants to develop a pore space project that's going to include state lands? So I'll leave that question.
So very much like the other agencies, the Office of State Lands is in the early stages of developing these kinds of authorizations. So I can tell you what we know and what is still being worked out by the Office of State Lands. So the basic process is this. To get a lease for pore space from the Office of State Lands, you would negotiate an individual lease. It is going to be a special use lease from the Office of State Lands. Once that is approved and agreed to by an applicant and the state of Wyoming, the Office of State Lands, that then goes before the State Board of Land Commissioners, which I think people in this room know are the 5 elected officials for the state of Wyoming, to actually approve the lease itself. So that, in broad strokes, is how the process works. Now, to my knowledge, there has only been one such lease that's actually been approved to date. It was approved by the state board in February. And so we're on the very early stages of sort of knowing what these leases are going to look like. But I think we're starting to get an inkling. So what are some of the features we're seeing in the state lease? One of the things is the compensation structure, at least in the one that was approved, sort of has a couple different components. It has some initial bonus payments that would be made by the lessee at the time of execution, and then at particular milestones throughout the lease. And then there's an injection fee. So think of it as sort of a bonus fee for the benefit of using the state lands initially theoretically, and then once you start injecting, you would pay a per ton injection fee. There's some diligence markers in there. So there's specific times that the lessee would have to satisfy in terms of getting its permit from DEQ. So there's sort of an operational term. There's a construction term by which you would actually have to start operating and injecting. There is then a term where you're going to be basically operating and you're going to be injecting, and that could be fairly long. And then there's going to be a site closure and sort of remediation term. So there's going to be sort of a series of stages, call them diligence, if you will, that we're seeing in these agreements. The other thing that I think that the state lands is, and this is good to a certain extent because it is Wyoming, there's a flexibility, but they're looking at identifying specific formations. So the lease would be an exclusive lease for the pore space, identified, but it could be specifically by formations or potentially by a certain depth and everything below a certain depth. So in other words, unlike what we're seeing, at least potentially with the BLM lands, you are going to get an exclusive pore space lease, so nobody else could sort of inject in that specific pore space of state lands, but they are at least initially looking at sort of doing it formation by formation.
Well, that's a great overview. I guess something that we didn't touch on, for all you that have worked in energy development, we know most of the time you're going to get 100% of the landowners to agree. But in that unlikely scenario, you can't get 100% of the landowners to agree in a project. What are the options for a developer? What does that look like? Can you have a project go forward if you can't get 100% of the landowners to agree?
So Wyoming does have a geologic storage unitization statute that is sort of modeled off of the oil and gas unitization statute in that it requires you to get a certain percentage of consent of owners, and then you can go forward and sort of unitize the project. This hasn't ever been done before, and so there's a lot of questions about how this will work. First, it says that the calculation of the percent of owners is based on ownership of the pore space capacity. And so there's a question of how you're going to determine the relative capacity, whether you're going to have specific geologic data. That may depend on whether you've done more geologic characterization and seismic, or whether you're going to use surface acreage. And then it says that the non-consenting or non-participating owners would have a share of the economic benefits of the project. But it's very unclear how that's going to be calculated and what that's actually going to look like and how those models are going to develop. So I would say that the framework, the basic framework is there. It requires notice to people within that proposed storage area. This is handled by the Oil and Gas Conservation Commission. So there's a lot of things that look familiar, but there's still a lot of questions about how these will be worked out, and then how that process will interplay with DEQ's process as well.
Well, I guess we have a question, and so I'm gonna pose a question from the audience. Larry's got a question.
Thanks for that. I mean, just following up on that, Tara and Andrew, do you think there is legislative action that needs to be taken or will be taken to, as this becomes more real, to address some of these open questions? Because an interim committee, I think, is going to take up parts of this statute this summer.
I think more clarity would be really helpful, for sure, right? I think that's true at every level, right? I think clarity from Congress to federal agencies could be really helpful. I really commend those agencies for working creatively within the authority they have so that these things can go forward and not just waiting for Congress, because we probably wait forever. But then also I think the state legislature can add more clarity as well, and really move these things down the road. And so yes, I think there's an opportunity to do that.
I'll just give my answer, and the answer is yes. I think there's a lot of things that can be clarified, because when they came out with the unitization statute, no one really understood what one of these projects was going to look like. I think we're getting a little bit better sense, and I think we can really go back and reevaluate those statutes. That's my personal opinion. A couple things, as Professor Righetti said, I do think that we need clarification on what it is an economic benefit to a party that didn't enter into an agreement. Another thing, there's a lot of things to be looked at. Our neighbors require 60% consent of the landowners to basically get the other 40% of the pore space. Here in Wyoming, it's 80%. So we need to understand, is that a correct number? I think that some research can be done on that issue. So I'll continue with a couple more questions if our panelists are okay with that. I'm putting him on the spot, but Steve Degenfelder, so I'll give him the floor.
Thanks, Steve. I had a question for Dr. McLaughlin. Just to follow up, I appreciate you giving us all a reality check on how difficult it is to find a good injection reservoir. But my question is finding that
seems to be about as difficult as finding a new oil and gas field. Once you do find that, can you give some comment on the ease or difficulty of doing this MRV report that qualifies the project for 45Q tax credits? And have you seen anyone actually get the 45Q tax credits from the IRS to date?
Absolutely. So great question. So the MRV question, which goes down to 5 minutes, the risks that might be involved, and how do you monitor and improve it? So monitoring and improving comes a lot down to how much you understand the subsurface and the science. There's geophysical, there's wellbore monitoring. So there's a lot of people with ideas there, and that's still something that needs to be firmed up. That'll take a little while. In terms of tax credits, I do believe Red Trail's off and running up in North Dakota. I think unfortunately they got their stuff set up prior to the 85% or $85 per ton, so I think they're still making the lesser amount, actually, and they probably have lawyers on the case there to try to shore that up. Exxon put in a fairly basic MRV for their project in southwest Wyoming, but they're doing a CO2 EOR project. Again, it comes down to the feasibility and the comprehensiveness, I think, of your monitoring plan relative to the risks you identify. So there's still a lot of work to be done there. There's not a clear template, so to speak, but we're trying to be as honest as possible with it. We're going to make leakage risks. How are we going to be able to monitor and prove that? And that's what the EPA, or in some cases our DEQ, wants to see: science-based decisions to make the MRV as robust as possible. And I don't know if I truly answered your question, so catch me later.
And I did see we have a question from Sam Mowry. He was a student my first year teaching, a former AAPL student nationwide of the year, currently with Shell. So I'm going to give Sam the floor. He's got a question.
A dumb question at that. How is this monetized now? How will it be monetized in the future? And what are the key value drivers?
So 45Q is, and I'll kind of address both of your questions a little bit. 45Q has been around for a long time. And injecting CO2 into the ground isn't new. Injecting it under the Class 6 program is new. But injecting in Class 2 wells, including acid gas injection wells, has been around for a long time, and there is some Treasury guidance that says that is a qualified carbon oxide under 45Q. So there are Class 2 pathways. So 45Q is one way that you can approach this. I think there is another thing that people are trying to access voluntary carbon markets as well, which you can monetize tradable carbon credits. When you see, like, when you fly United and it says, do you want to buy some carbon credits so that your air travel is zero emission? What you're doing is paying for credits in a voluntary market that somebody else has generated. So that's another potential way that some people are trying to monetize this. And then I think one of the huge drivers, which maybe gets less attention, is advantaged products. And that is that due to policy both here and, but also really globally, there is a growing demand for low carbon products and low carbon alternative fuels. California has the low carbon fuel standard, but for example, the EU's border carbon adjustment mechanism was just passed. If you're going to have zero carbon fuels, which could be blue hydrogen, which uses CCUS, if you need ethanol with CCUS, to get that to zero carbon, you're going to have sequestration. And there's an ESG sort of finance side driven demand for that, those products. And then in some markets globally where these products are going, they're a compliance market. And so the people will be required to demonstrate the carbon intensity of their products, and products that have lower carbon intensity are going to have more market opportunity. There's a huge drive to be one of the first movers in that space.
All right, thank you. Unfortunately, we're about out of time. I know there's a lot of people with extra questions. Our panelists, I think, will be around here a little bit longer. Feel free to approach them. I apologize. We would love to answer all the questions. I just want to take this short opportunity to really thank all of you for coming out, supporting our event, supporting our students, and supporting our program. It means a lot. And thank you so much to this incredible panel on, really letting you all know how one of these projects might work. So, I do want to thank you all and thank our panel. Thank you.
I have to go get my other. Oh, there you go. All right. I'm going to get my purse so I know that I won.
Okay, sounds good. All right. I don't like this because everyone's going to be staring at me. I don't like this. Okay, well, I'm waiting on Eli, sorry. Yeah, I know. All right, everybody. I'll keep this brief so we can all get out of here and enjoy some nice weather. Just first off, can we just give all our speakers a round of applause, please? Yes, they did a very good job. We really appreciate them sacrificing their time, taking time out of their schedule to, come here and, talk with us, meet with us students and just share their industry insight to all of us. So we appreciate that. Thank you, Holly. Thank you, Holly, for letting us do this, and starting to sound like it might be an annual thing. So, but anyway, thank you very much, Holly. Just thank you, Cammie, so very much. Thank you, Chris, Christine, Carolina, Helen. I mean, everybody at SER that pitched in and helped us put this on. We could not have done it without you. I'd also like to thank our sponsors, AAPL and WAPL. So we could not have financed this on our own, so thank you all very much. And then to you attendees, we obviously, if none of you guys showed up, there's no point in doing this. So anyway, thank you all for coming, and hopefully we'll see you next year. And then I'd like to thank all these guys over here. I know they probably get frustrated with me every once in a while, but this is the best working team that I have ever been a part of. I mean, they're just incredible. They work very well together, and they've done a lot for me. So thank you guys. I appreciate it. And then personally, I would like to thank Eli, because we came in here in the fall of 21, and it was Eli and myself for the student chapter. And just to see where it is now, here, almost 2 years later, is pretty incredible that we've been able to do this 2 years in a row. And, we've got a great executive group coming in next year, and just really investing in these younger kids. And so, Eli and I, we have put a lot of hours into this. And so it's a little bittersweet because we're getting out of here. But anyway, thank you. Finally, I'd just like to thank our industry advisory board. We really appreciate you guys. You're always open to listen to us students, and you always give great feedback. And when we have crazy ideas like putting on conferences like this, you back it all the way. So thank you guys. And I think, one last thing, another shameless plug. If you guys would like to continue to support the Student Chapter of Energy Resources, everybody has a flyer on their table, and so that goes to just help us put on stuff like this. So that merchandise is available through May 21st. And so we really appreciate you guys, everybody coming. And so anyway, without further ado, I think we can draw for the raffle items. So. All right, shake it up. Oh, okay, yes, this is for the Yeti cooler and the little coffee mug and the blanket. Okay. All right, here we go. I have 730463. John, all right. And John, we'll get those to you. Yeah, they're sitting outside. Okay. Next, yes, is the purse and the wine tumbler. All right. 730638. 638. Helen, all right. And this is the whiskey decanter set. All right. Okay, we have 730588. All right, Doug. All right. All right. Thank you guys. Just one more thank you. We really appreciate it, and you guys travel home safe.